uh, on July 16.
But came from a different series filed by a different slab will not get control. No control.
Not a problem. Before the damage was done, it has been resolved because before the next day.
Otherwise, embarrassment before client.
ওটা ওখানে লিখে নিন। Full stop, paragraph.
Your Lordship, I appear for the petitioner. I'm led by Mr. G2.
Matter was mentioned, I am told my lord's desire was this should go to the regular bench. My lord, we have no difficulty, my lord, in doing the matter. We are ready with the matter.
What is the extreme urgency? It is fixed on 30th. So go and argue there on 30th. Yes, but go and argue there on 30th. I cannot decide if the,
starts. Can you have a look at the affidavit page?
if the matter is returnable day after tomorrow, will it
urgency, Lordship.
all the urgency you can place day after tomorrow? What will happen in 2 days? For so long you have suffered. Then you argue before the regular bench. I don't find any. Your appeal will be infructuous.
He wants to open up an office in New Delhi. This is
Now, why will it be infructuous?
Now they have.
No, then if it is prayed for an adjournment is prayed for on behalf of the petitioner.
Can you have a look at the affidavit page? Then my lord
Let him
can
conclude.
decide whether my lord will attempt to take up this matter.
Unnecessarily, because I am very the matter is returnable on
Affirmation
30th of
process.
July. You want the revisional court to intervene. Why? It's so urgent that it cannot wait for 2 days. So what? Corporate bodies cannot wait for 2 days in opening the office. The injunction order was passed when?
Passed on 21st May, Lordship.
21st May. When did you prefer appeal?
1 month. No, after 1 month.
Statutory limitation period is not the thing. If it is urgent, you should have preferred it in 1 week, 1 day. When did you prefer the appeal?
I prefer the appeal on 19th.
19 June. So almost after 1 month.
After 1 month,
Just before the expiry of the, where is that urgency? Where is that pressing urgency that you cannot wait till 30th?
other meetings were going on.
So what? So what do you continue? No. Liken in.
Lordship, kindly allow me for 2 minutes. Kindly allow for.
Very well. Unnecessarily, you'll be wasting time of court. These matters, please don't bring unnecessarily.
Kindly take up the paragraph number 16 of my. I'm facing monetary loss, Lordship. They have
Monetary loss can be compensated. That is no ground to grant stay. Monetary loss is exactly the ground to refuse injunction. C41 of the specific relief act. Why are you mentioning these matters unnecessarily? You mentioned as if it is so urgent.
Kindly allow me to come late tomorrow, Lordship. I am led by Mr.
No,
Pankaj.
you go before the regular bench then. This matter has been mention it unnecessarily. You don't want to move.
Lordship, I'm appealing for the respondent bank, Lordship.
এগুলো দেবেন না লিস্টে, আমাকে জিজ্ঞেস না করে লিস্টে দেবেন না। এগুলো এগুলো কেন দিয়েছেন লিস্টে? লিভ ফাইল
These matters already pending before the DRT Kolkata 1, my lord. My lord, previously we have applied before the concerned bank respondent to make amicable settlement, my lord. My lord, page number, representation page number 25, my lord. In this regard, after receiving this representation, my lord, the concerned bank sent us a letter, my lord, which is page number 31, annexure P5, my lord. My lord, paragraph number 2, my lord. May I read, my lord? Regarding your reference to the judicial proceeding, we would like to clarify the actual context and contents of the Honorable High Court at Calcutta's order passed by Her Lordship, the Honorable Justice Amrita Sinha on September 22, 2025 in your writ petition WPA
Where is the order
7206.
passed by this court?
My lord, last line, my lord, the
No,
Honorable
where
Court
is the
simply
order?
direct that, my lord.
Where is the order passed by this court?
My lord, last line, my lord. The Honorable Court simplified direct
Lordship,
that.
it's not
Show me the
adjudged.
order passed by this court.
Yes, my
Don't
lord.
read the letter. Show me the order passed by this court. You had approached this court by way of a writ
My lord,
petition earlier. Where is that
My
order?
lord, the learned Honorable Court, my lord, directed the.
Show me that order. Where is that order?
My lord, kindly, my lord, read, my lord.
The order
Kindly,
is
my
not
lord.
Look at
attached.
the order, sir. You
My
don't
lord,
have a
kindly-
copy of the order.
Give me opportunity to
No,
read,
no,
my lord.
please show me the order
The
first, then I shall go.
honorable matter be the matter be placed before the next Lok Adalat to explore the possibility of an amicable resolution. My lord, we want to settle the matter through.
I want to see the order
Lok-
first.
Lok Adalat
First
or
answer the query of the court,
mediation.
then you argue. Please show me the order.
My lord, I am kindly give me opportunity next day, my lord.
Then why did you not bring the order today? Unnecessarily you are moving. You want me to read your letter without showing me the order.
My lord, this letter issued by the
So what?
bank, my lord.
So what? Whether the bank's letter is right or wrong, will I not be able to see that? I mean, I am not entitled to see that. You will not show the order, you will only show the letter.
My lord, we want to settle the matter through Lok
That is
Adalat.
between you
or-
and the bank, the court. That is why I wanted to see the order. What kind of order was it? Was it an order directing the bank to enter into a settlement, or is it was left open to the bank to consider your representation?
My lord,
What was the nature of the
my
order?
lord, yes, my lord, my lord. My lord, but the respondent bank
Again, you are.
admitted the fact, my
You
lord.
show me the order. You have a copy of the order.
Lordship, I do not have.
Next,
Lordship,
my lord.
kindly pass it over for.
Passing it over. Bring the copy of the
Please
order.
bring
No,
the
next.
copy of the order, Lordship.
Lord, second half, my lord.
Passing it
Passing
over. You
over.
please wait. See when it
Lord,
is called on.
After
Bring
2
the
p.m.,
order.
my lord. After 2 p.m., second half.
Whenever it is called after 12.
Lordship.
After 12. Lord.
Bring a
Yes,
copy of the order in the meantime.
My lord, in this
Old
connection,
Lordship, I am for the petitioner.
my lord, what
Side to
is
side.
revealed that in the writ petition, my lord, the annexures are missing. However, my lord, we have gone through the writ petition filed by my learned friend. So, my lord, give a direction past, my lord, so that we can conduct an inspection and come back the report.
And Lordship, I have also served the private respondent. Only thing, the affidavit of service is not affirmed. If Lordship gives me half an hour, I will come back with the affidavit of service. Not affirmed, affirmed.
That means affirmed হয়নি বলছেন তো, তাহলে আপনি নিচ্ছেন কেন?
Private respondent says received.
Hey, Nam. May it please your lordship, I am for the petition. My lord, kindly see the last annexion. That is the dues, page 61. 3,82,689. In the meantime, on 17 June, they have disconnected my electric line. I am not trying restoration of that line because want to pay. There is a demand of 9,65,377.
50% has been paid.
बोलते देना. Most of payment has been made. Only dues is 3,82,689. We want to pay that amount, and we don't want to restore the line. What I am paying in order to payment of this amount, we are not paying for restoration. Let it be paid after 1 year by installment.
1 year.
After 1 year.
My lord, so ridiculous.
I can withdraw this matter because line has been restored and payment has not made.
You make a representation, they will consider. Mr. Haldar, these installments I
My lord,
cannot
matter
grant.
has been concerned. This is the third round of litigation.
He wants
So-
installments. You consider
Installment, that too after 1 year.
that you consider.
Right.
Say, I cannot say on your behalf whether you will do or not do.
I can withdraw this writ petition, but I want to pay them.
I will record that and I will give you opportunity to file a representation before them. They will consider it and dispose it of.
No, we will consider that.
This
This is
writ petition.
round of litigation.
I know that, but factory is closed.
This
He
writ
cannot
petition
run
has
the
been filed.
factory. For that, he is not paying for restoration. Electric চাইছি না তারপরেও টাকা দিয়ে সেটাই তো বলছি আমি উইথড্র করে নিতে পারছি
Challenging a letter dated May 16, 2026 issued by the respondent CSC authorities calling upon the petitioner to pay a sum of rupees 3,82,689 towards
My lord, autonomous is I for petitioner before Lords, my lord.
Who is appearing for the respondents?
My lord, I served the my lord notice to them, my lord, on the 22nd July 2026 by hand there. But my lord, yesterday my clerk has not come. That therefore, my lord, I could not prepare my lord affidavit service, my lord. But there have a acknowledgement.
By hand you have served, they are not appearing. Serve again. What is the problem?
My lord, my lord grievance is, my lord. One, my lord, notice has been, my lord, affects by the advocate commissioner for taking the physical possession. My
Why
lord,
are you
he
not
affects the
taking DRT? Why have you
no,
come
my
here?
lord, my grievance, my lord, I am not borrower, not
So-
guarantor.
so-
My property, my lord, has, my lord, mortgage to the, my lord, another bank.
These issues, how will the writ court decide? How
No,
will
ma-
the writ court decide this?
my lord,
These are
my
factual issues. How will the writ court
my lord,
decide?
the respondent, my lord, without having any right, my lord, they are, my lord, depriving my
Very
property.
well, the DRT does not say that only borrower or guarantor will come. The
My lord,
Surface Act
borrower
does not
and
say-
guarantor. I am not borrower.
Surface Act
Guarantor.
does not say that only borrower or guarantor can come.
Yes, my
Section
lord, there have a
17 is
provision
wide.
of the, my lord,
It
third
says
party.
any person
Any
aggrieved.
grievance, any
person
party has
aggrieved.
been grievance.
You can approach that because
No,
how
but-
will on affidavits, how will I decide this? You tell me. On affidavit, you say it is not your property. He will come and say it is your property. Ultimately, it will be oath versus oath. How will I decide this question?
No, my lord, my lord, here is the issue is that, my lord, there have a, my lord, one injunction order. My lord,
Whatever is there, why is it not being assailed? This challenge is not being
my
thrown.
lord, the borrower and guarantor, they are already agitated the issue before the DRT.
So,
I am
work
not.
there and get it done, get it thrashed out here. Unnecessarily, one part of the litigation will be there, another part of litigation will be here.
My
It
lord.
doesn't make any sense. And you know there are Supreme Court judgments galore on this point.
Yes, yes,
So
my
that
lord, there have a.
your remedy lies before the DRT.
But my lord, my grievance is another, my lord. They are, my lord, they are have a, my lord, another property, but my lord, they are demanding my property. Therefore, my lord, I become before.
Serve again. Serve and
My lord.
For the state, my lord, Mr. Srinivas. State. Blank for the deputy.
My lord, I filed a section 17 application before the honorable, before the learned DRT Kolkata, and subsequently one notification issued by the government, and the matter is transferred to Siliguri. In the meantime, district magistrate passed the section 14
so
order.
if matter is of pertaining to Siliguri DRT, then how will this principal bench have jurisdiction? The Siliguri
I again,
DRT is in session. Please go there. If Siliguri DRT was not, Siliguri court was not there, Jalpaiguri circuit bench was not functioning, you could have moved it here.
just a minute, my lord. I visited the Siliguri DRT and put up application for urgent hearing.
Sir, against the DRT, Siliguri DRT is
Pass the order.
yes, The Jalpaiguri circuit bench will have determination, not this bench. Jalpaiguri circuit bench is having jurisdiction now. Jalpaiguri circuit bench is active. I don't have.
Correction, this is a.
I am not challenging that notification. District Birbhum, my lord.
He says Siliguri DRT's order is there.
Birbhum district, so for DRT is concerned, that is which Siliguri.
So Siliguri DRT will come under the jurisdiction of the Jalpaiguri circuit bench.
He has
No,
challenged section.
I am not,
Section 14 order is assailable before the Siliguri DRT.
Yes.
Then
my lord, I am not challenging the DRT's order of
then
Kolkata
section
or
14
Siliguri
order.
anywhere.
Section
I
14
challenge the order of the Block Development Officer Birbhum.
block development officer.
Yes, my
How
lord.
can block development officer pass?
Yes, that is the question.
Show me. What is this? What is this? What are you handing over?
After filing the writ petition, all of a sudden, in the meantime, when matter is fixed for 12th August, in the meantime, 5th August, they pass the order for physical position, which is infractuous because district magistrate passed the order in 2025
So
and
what?
in a time-bounded manner. Kindly look into the page 141 of the writ petition.
Mm-hmm.
141, my lord.
Yes.
The ordering portion of the Planet District Magistrate, para G, last paragraph, para G, the exact date of possession of secured asset forwarding thereof to the secured creditor shall be fixed by the authorized officer in the development, block development officer, Bolpur Sriniketan, in constitution with the district divisional magistrate, sub-divisional land and land reform officer of the local police station, secured creditor and borrower concerned. The exercise is completed within 45 days from the date of passing this order. The order is still after 400 days delay. They are passing the block development officer send that impugn notice. They don't have any power. This is a stale order. They try to executing in now a days when matter is fixed in 12th August. They with deliberate intention they pass the order in 5th August. So I come before the writ court. There is no efficacious remedy pending before me. The order is still, the order is passed in 26th May 2025. From that date, within 45 days, block development officer has the power to implement this order.
That is just execution of the order. It is not that the order itself will go after expiry of 45 days. There is no such law, and the order will become stale is also not right. If that is your grievance, only grievance, then that is neither here nor there.
So how block development officer
Of course
implement
he can.
a stale order,
He can.
which is time barred?
He's always empowered. Yes, sir.
So far his grievance is concerned, DM has deputed this person as his subordinate officer to execute the order. So my lord, until and unless this order gets executed, and not since he has already challenged, it is there before the DRT.
The DM's order is under challenge before the
Yes.
DRT. Then how are you coming here?
Then-
If the DM's order is under challenge before DRT, this also.
No,
should
I
be
did not challenge the DM's order.
He says he is challenging.
No.
you.
My instruction is that
Wrong
essay was
instruction.
already filed, that essay was taken up on 20th of July. Now the matter is fixed on 12th of August, and my lord, DRT has not passed any order of stay on the court.
In the
He
meantime, they
says
passed
DM's
this order.
order is not under challenge. Please be clear with your submissions. He says DM's order has not been challenged before.
I never challenged it.
What is your instruction on that?
My instruction is that he has challenged, he has filed essay challenging notice under section 13(4). Thereafter, he has.
So DM's
filed one
order-
time. That,
Whether DM's order is challenged or not, don't
My
go
instruction-
circuitous way. You
No,
can
my-
directly answer the question whether DM's order has been challenged or not. That is the.
No, my lord. I never challenged
Sir,
the
let
proceedings
him
of the.
answer. I'm not asking you.
Oh, yes.
my instruction is that because my lord, I am not appearing before the learned DRT. My
You
instruction
should have
is that-
taken, this is not an answer to
No,
court.
my instruction is that he has challenged that order before by way of an act.
By way of an IA, you have challenged. the
I
order.
never challenged the process of, this is a at ministerial order of the district magistrate. I never challenged it, my lord, in my petition. All the annexure is annexed herewith in this writ petition. I never challenged it.
Come
I-
back tomorrow.
Page 25.
Dr.
Page 25.
Page 20.
Page 25.
You are appearing for whom?
For the state led by, sir.
Only page 25. They have
They have
challenged
challenged the
Five.
section 14 order.
14 orders.
The date is incorrect, but it's 28 May they have challenged. Kindly come to page 25.
25, internal page 25, main page 47. 25.
Internal page 25 of?
Malata.
Page
Volume one.
25 of the writ petition is the part title of
Main page 47. Main page 47, internal page 25.
47. Yes, you have challenged the order passed by the
last line,
DA,
last
page
line.
47. What are you saying?
No, I challenge, never challenge the proceeding of section 14.
You have
I
challenged.
just give a interim relief for the
Eight, my lord, I appear for the petitioner, my lord.
I am applying for the respondent number 8, my lord. They, my lord, just received the notice, my lord, and they action.
I served, my lord, long before, my lord. I served long, he may have received now, my lord.
I have one day time, my lord.
I am from my lord.
Tomorrow,
My lord,
tomorrow.
Tomorrow.
my lord.
I'm for WBC. It is second round of litigation. My learned friend appears first. আগে তো appear করেছিলেন।
You are appearing for the private respondent.
Private respondent number 8.
Private respondent was the petitioner in earlier litigation.
Very well, he wants time, let him come back up.
My lord.
Not today.
Lordship, I am from the state. And here, we have been looking for the instruction, but we didn't get this.
Very well, I have kept it tomorrow. In the meantime, you take instructions.
Your
I don't
Lordship,
think state will have any.
No, my lord, actually, my lord, district magistrate's order, my lord, has been challenged. My lord, it is quite clear in the order itself.
No, my lord,
Very
I
well.
have challenged on my lord, I will place it.
Then should I keep it after one more day?
yes, I will be highly obliged then.
My lord, I don't have any objection, my lord.
Let us have it on Monday. Then she will also have instructions. He will also have fuller instructions.
My lord,
You want shifting, so it won't be problematic on Monday.
at top, my lord, on Monday top.
Monday, my lord,
Monday will be
Monday is
monthly
monthly list, my lord.
Tuesday.
The after affirming, Lordship, I am tendering
Lord, I am for the WBSCTC.
the petitioner is a valid agricultural having the electricity connection, Lordship, and the private respondent proposed to get the electricity connection within 40 meters from the transformer of the petitioner existing transformer, Lordship, which is overloaded, Lordship, and burden not feasibility of electricity connection and lot 440 volts, Lordship, and no new transformer was installed for affecting the electricity connection to the private respondent, which is overburdened. The electricity connection is not frequently and not loaded the electricity affecting the connection to the petitioners for agricultural purpose only within 40 meters, not maintaining the 200 meters for existing for irrigational purpose submersible pump, Lordship. No further transformer was installed for affecting the electricity connection to the private respondent, which is not permitted in accordance with law, Lordship. The objection to be heard out by the authorities concerned and it is in order to be passed, and the
My lord, there is no prohibition in the either in this regulation or in the statute.
40 meters.
The 200-meter norms is not there. Why my learned friend Simla's raising, he has no right to.
That prohibition is not there.
No.
Earlier it was there.
No. It was earlier, much earlier it was there, but subsequently, my lord, under the my lord, Groundwater Act, there is no distance norms. And in the Electricity Act regulation, there is no my lord prohibition. How my learned friend saying, even my lord,
Where is the prohibition?
electricity
Show me
connection,
the
Lordship.
prohibition.
Let's say
Which
in
law prohibits?
Lordship, the natural sources to be protected under the central.
You cannot suddenly come up and say that it
No,
is.
Lordship.
Show me the law that it is prohibited.
Then Lordship, then make it not today, Lordship.
there is no law.
Bring the judgment also, Lordship. The natural sources
Is there
to be
any law?
protected.
Is there any law? My state can say he is the GC.
Her petition letter.
No, I am not in this. Well, how am I am not.
Show us
Yes,
the
Lordship. And then, Lordship, make it not to the Lordship, I have to place the judgment, Lordship.
লিখে নিন।
The natural sources to be protected, Lordship.
That is there, but
Yes.
natural resources cannot.
Day after day after
That does
tomorrow.
not.
Item number 10, my lord. Disappear.
My lord, I am appearing for the petitioner, my lord. I have served by mail upon.
Mail service, Mr. Mitro, mail service, I do not take cognizance of.
I tell you, Lordship, by mail I have served upon, my lord, police
This is not that sad.
and my lord, finance company.
Mail, what is your grievance?
My lord, grievance is, my lord, that my lord, I have been, my lord, completely, my lord, fraud, completely fraud, my lord. Fact of, my lord, actually fraud entire, my lord, proceeding will vitiate. My lord, I am the owner of the land. A development agreement was made, and my lord, thereafter there were specific portion earmarked for me. And my lord, after some years, my lord, it was found he is not working properly. We terminated his, my lord, agreement. Thereafter, I find, my lord, we have constructed our part. My lord, structure was there. I am very clear. But my lord, other parts, my lord, was not completed. My lord, floor or other parts, we completed and we are residing there. We are the owner. We have not taken any amount, any one single part thing, my lord, from anybody. Now, my lord, all of a sudden, my lord, last Friday or Saturday, my lord, somebody came, a group of persons, and my lord, police also came, and my lord said that this portion was sold to some persons, and my lord, they have said that surface, my lord, they have got an order from the tribunal, and my lord, this notice was, my lord, pasted on the ground floor. My lord, page 76. My lord, I am, my lord, I have not taken any loan. If there is any loan, they let them proceed. And my lord, here, my lord, I beg to submit, my lord, before your lordship. My lord, we are residing there with our family, my lord, children. Now, my lord, what will happen if we are thrown out? That's why, my lord, speedy. I appreciate, my lord, that, my lord, procedure. But when if the entire procedure, if your lordship
Please
found,
serve and come. I am making it returnable day after tomorrow. Please serve and come.
my lord, my lord, I have sent by
No, no, speed post, I don't recognize.
my lord, by hand.
Yes, it's
leave. My lord, these, my lord, only can be agitated before, my lord, reach court. And but there are definitely some procedural matters are there. My surface is tribunal, my lord, this is a tribunal. Of course, my lord, that is a. My lord, I will come back, my lord. I will find out.
Yes. Thank you.
Get
लिखे नहीं. None appears for the petitioner.
I'm praying for short Passover.
Abhay for CSC, my lord.
Passover. Passover. Yes.
Lord, I am for the respondents. Last occasion also they didn't turn up.
ওই 15th জুলাই যেখানে লিখেছি আগের ডেটে 15 ছিল তো নানা পিরিয়ড অন 15th বলে এক জায়গায় লেখা আছে না এটা 17th হয়ে যাবে বাকি সেম ঠিক আছে বুঝতে পেরেছেন তো ডিসমিস ফর ডিফারেন্স নেক্সট
এটা নিয়ে
14, my lord, I am for the petition.
Lord, I appear on behalf of WPSC.
In this matter, my lord, what happens? This writ petition has been filed, my lord, assailing the SLPA, ILPSC charges which were demanded by the concerned authority of the electricity department. My lord, initially they demanded, my lord, 4,81,000 towards the outstanding dues which they claimed. My lord, that was, my lord, the order was passed by the Honorable Justice Sobhusachi Bhattacharya, quashing that order, my lord, and not to pay anything. Subsequently, they have demanded, even after this order, which has been, my lord, interim order is there, passed by the Honorable Justice Nijamuddin, my lord, and that's why, my lord, the whole thing is there, well, not decided. My lord, LPSC charge, or LPSC charges, they are demanding one after another. Your lordship will be pleased to see the order. First demand, my lord,
First demand, it is in
which they, my lord, made, and I page 13 onward. LPSC charges. In
Whatever my
that amount,
senior friend is
one after
submitting,
another.
my lord, is absolutely correct.
page 13
Page 13 onward.
page
13, 14,
is the order.
LPSC charges.
What is the Sukumar Das
My lord,
cost title is your cost title is Sukumar Das.
Sukumar Das, consumer Sukumar Das.
Page 13 is the
Page
part of an order of the of
Bills which are raised.
page 13 in my copy
And
is this is the order.
last one, my lord, page 20.
Page 13 is the order passed by a single bench. Oh, this is your supplementary affidavit. Sorry. Your writ petition is thinner than your supplementary.
My lord, kindly come to page 7, the what is the prayer?
Let me first understand this case. Yes, page 13.
13, my lord, bills which were raised by the authority concerned, demanding LPSC charges. Page 12 also, I made the application and they deposited the amount. Bill was deposited. But immediately thereafter, page 20, your lordship, last one which was raised before filing this writ petition.
Yes.
And supplementary affidavit, my lord, the order which was passed by the Honorable Justice Sobhusachi Bhattacharya, I have annexed that order. That judgment is there.
So according to you, you are not liable to pay LPSC.
No dues.
Since it is a billing dispute, my lord.
Regular bill is to be paid.
My lord, since it's a billing dispute, it should go before the GR. My lord, kindly come to page 7.
What about the order passed by the Honorable
My lord, that
Secretary?
is there. My lord, I cannot stay away from there. My lord, there are another thing which I want to submit. My lord, in terms of the order which has been passed by Justice Bhattacharya, it is very specific. If I say, I cannot hide away that the provisional order and the final order has been set aside. And subsequent to that, my lord, there is also a direction.
Nothing has been communicated to me subsequently.
না, আমি ডিরেকশনটার কথা বলছি।
There is also a direction at paragraph 48.
Paragraph 48 is urgent certified.
45, paragraph 45. Internal page 15 of the judgment, my lord. The WBSCTC directed to restore electricity connection to a petitioner has
Yes,
been
provisional and final order has been
set aside. And my lord,
Now, if
kindly,
LPSC charges are on the basis of the provisional and final,
yes.
then what
My lord,
remains?
may I, sir? My lord, in that regard, my lord, may I come back on Tuesday? Because why they have charged that has not been specifically stated.
The basis
My lord,
goes.
I understand, my lord. My lord, kindly see, it is stated that needless to say, no further charges, including reconnection charges, shall be levied on the district.
Yes.
Yes, that is there. May I come back, my lord? If it is wrongly done, my lord, I will come and serve.
Everything is exhausted there.
I will come and serve because my lord,
Additional-
until and unless I get a
Well, you come
specific
back. So
instruction.
why on Tuesday? Why not tomorrow?
No affidavit has yet been filed by.
দরকার নেই তো।
Not required.
My lord, from tomorrow till Friday, I've got some difficulty. My lord, come.
Saturday.
Till that they will not demand any further, my lord, because after that
Well, they don't take coercive steps.
No, we have not taken. We have not.
they are demanding, my lord, even if they
বাবা আমি যদি ডিমান্ড করি আমাকে
তাহলে বলে দেন আপনি।
আমাকে
না হলে বারে বারে নিচ্ছে না।
come back on Tuesday, my lord. Kindly give me time.
Four lakh 66,165.
Where are you reading? Where are you reading? Page 16.
4,66,125.
Where? Page 16, where?
Page 16.
Yes, where?
My lord, bill date 2nd February 2023.
Yes.
That demand. This is not the regular bill.
465,735.
466,165.
466,165. Now this 466,165 was the amount in the final assessment bill. No, it was 8,67,680.
And from page number 13, if my lord sees 13, my lord, it sees that it is the billing period is December 22. The next one is My lord, at page 16, that is, my lord, that is January 23.
Which
Of
one?
actor for actor. Page 18 also, my lord, 4 lakh
Sir Hajra,
57,000.
probably I have not been
Have
able to
print.
make myself clear to you.
Billing period is 22.
LPSC page 18
Mr.
LPSC.
Hajra, please understand the quote first, then you go on to your submissions. There was a final order of assessment against
My
you,
lord.
which was set aside by the coordinate bench. The final order of assessment asked you to pay 8,67,680. Now this was quashed. This order was quashed. Now this 4 lakh and odd LPSC, this 4 lakh is LPSC or this 4 lakh is the bill?
No, 4 lakhs LCB. LPSC charges, my lord. Your lordship, page 18, kindly see. At the bottom, my lord, 12,603. 18. Page 18.
Yes.
At the bottom, my lord, right hand side. 12,603.
Now what
Along
is the
with
basis
that.
of this LPSC charge? What is the basis of this LPSC
That
charge?
this is in respect of the different bills. If my lord may kindly come to.
So it has got nothing to do with the final assessment.
My lord, kindly come.
No payment is due. Nothing.
You please indicate the basis.
I have.
Can he get the
This
electricity?
is. Problem is this. Harassing and.
So next.
My lord, I appear on behalf of CSC. My lord.
Matter to appear, my lord.
11.
Liken in. None appears for the petition.
Hearing for the WBACDCL.
Same order. Next.
But I have paid.
Same order.
Dismissed, Lordship. Inclusion of file.
Same order.
Same order to be disposed.
But I am for the respondent.
Same order. কবেতে লিখে দেবেন যে রেসপন্ডেন্ট লাইসেন্সি ইজ রিপ্রেজেন্টেড বাই same order.
দেখুস তো দেখি and for the respondent.
Yes.
The issue before your lordship is this, my lord, that whether either under section 152 of the Code of Civil Procedure or under section 151 of the Code of Civil Procedure, claiming the correction of an arithmetical mistake or omission can be done without correcting the body of the, my lord, the judgment. My respectful submission before your lordship will be this. To that extent, order is required to be recalled. Otherwise, if body remains the same, then they are on the basis based on which the calculation was made, that cannot be corrected. This is the crux of the matter before your lordship. Now, before I proceed further, kindly turn to the impugn order at page 133.
এটা কি দিয়েছেন দিদি? রেডি করে রাখবেন, ফালতু সময় নষ্ট হয়ে গেল।
তুমি বসো না, অনেক সময় লাগবে। দিল্লি last week.
133.
My lord, page 133, the impugn order. This is arising out of an order passed by the competent authority, wherein manner my application for recalling was rejected. Now, kindly turn to my lord. I skip over the facts of the relevant submissions made on behalf of the parties. Kindly turn to page 136.
Yes.
Points for consideration. Whether impugn order passed by the learned competent authority is proper, well discussed, covering laws and facts, and does not suffer from ambiguity, impropriety, and perversity. Whether the impugn order can be sustained in its present form or requires any interference. Decision with reason. Then, my lord, section 13, section 74. My lord, 74. It relates to the appeal. And under the Act 2013, your lordship knows. Then, my lord, kindly turn to the ultimate paragraph at page 139. In the case in hand, it is contention of the appellant that the land was wrongly measured and the compensation amount was paid to for 5.0527 decimal of land in place of 3.5434 decimal of land. The appellant not only intends to get it corrected, but also wants rehearing and to decide the compensation afresh, considering the acquired land as commercial property as the adjoining land had been awarded compensation on commercial rate. Rehearing the case and deciding the amount of compensation afresh certainly amounts to review of its own judgment by the competent authority, which he lacks. So far as the wrong measurement of land is concerned, kindly mark this portion. Concerned, the competent authority cannot be held liable for such mistake or errors as the parties themselves had jointly measured the land as 5.0527 decimal. Kindly mark this portion. They were present at the time of joint inspection, put their respective signatures on the joint inspection note. The appellant claimant accepted the amount decided as compensation for 5.0527 decimal of land and also handed over the said land to the Metro Railway authorities. There is generally no limitation period for correcting clerical or arithmetical mistakes in a judgment. As per section 152 of CPC, a court can correct such error at any time either on its own motion or on an application by party. The Limitation Act, which prescribes time limits for other action, does not apply to those corrections. In the opinion of this authority, the learned competent authority rightly decided that it has no power or scope to review its own judgment and the application is time-barred. There must be end of litigation. The party cannot be allowed to continue the litigation when the judgment has reached its finality and the claimant has received the amount awarded. Law helps those who are vigilant to their rights and not those who slept over their right. However, the appellant also cannot be allowed unjust enrichment. It is admitted by the appellant that only 3.5434 decimal of land of the applicant was acquired by the Metro Railway, whereas the payment was made for such and such. The public money cannot be allowed to be measured, wasted, and it should go to rightful claimant. Hence, it is. The instant misappeal is dismissed. The decision of the learned competency to dismiss the pair for review of the judge hereby affirmed. The competent authority is hereby directed to correct, rectify clerical mistake in the judgment without reviewing the matter on merit if applied by either of the parties. Well, I am joining the issue here. Now, my lord, kindly turn to why this body is required to be, the judgment of the body is required to be corrected. It is not a arithmetical mistake. This is not the suo motu that has been found by the court or the tribunal. This is who I pointed out after 12 years. That look, there is a mistake and the measurement which was taken jointly, accepted by both the parties, was wrong. On the basis of my application, there was another measurement. When it was found that my contention is correct. So according to me, my lord, that joint inspection report should go into the order of the judgment. Otherwise, calculation which has been arrived at would not have any basis. Now kindly turn to, my lord, my application first. Now before that, my lord, kindly turn to the order of the competent authority, the original judgment of the competent authority as page 80. Page 80. 80. Kindly turn to page 80.
Yes.
At page 84. I am just showing to your lordship the relevant paragraphs. Kindly turn to page 84.
Yes.
Why this is required to be corrected in the body? Kindly, my lord, the last but third paragraph, what starts with now? Your lordship has got it. It is to be seen what compensation will be justified to be allowed in favor of the claimant. It is admitted that OP acquired 5.0527 decibel land from CS Dag number 573, and evidence of PWW1 admitted this quantum lump as acquired land, and as such, there is no implement to calculate compensation holding quantum of acquired land such and such decimal. So if this is to be allowed to be retained and correction is being made in the arithmetical way, possibly this is not permissible. So until and unless my lord recall, my application for recall is being allowed, this cannot be done. But it cannot be said to be the correct, the arithmetical mistake, if I say so. Now, my lord, kindly turn to my application for recalling, which was, my lord, supported by Section 5 application. My application for recalling, your lordship will find at page 34.
Page
34. Page 34 mana annexed D to the application.
Page 34. Yes.
Page 34. My lord, kindly I skip over for the moment the other paragraphs. My lord, what prompted me to file this application after 9 years? Page 36, paragraph 5.
Page 36, para 5.
Para 5. Now, my lord, now the tenant of the applicant, namely Mrs. Bharat Marble Company, intended to prepare an application for claim, and at that when the said tenant started preparation, it came to the knowledge that an area under joint inspection with location against acquisition claim case number such and such, as prepared by Messrs. Nomas Private Liability, that is the petitioner before your lordship, owner, is not matching with the plan or the specification of the land area as mentioned in the schedule of the conveyance of the ownership. Thus, length of measure in joint inspection report dated 19/4/2017, but there is an earlier joint inspection report. In the acquisition claim case number such and such would be 73 feet 6 inches instead of 1707 feet. Beyond 73 inches, the case land not belongs to the petitioner. The case land area such and such is wrongly measured and wrongly handed over out of CS Dag number 70 instead of CS Dag number 578. So therefore, my lord, my respectful submission before your lordship, what has been recorded has gone into the judgment of the competent authority, rightly or wrongly. My lord, at the joint instance of both the Metro Railway, they have not objected to this. They were satisfied with the, the inspection and the possession that has been handed over to them. So that is required to be corrected. Now, my lord, at present, the construction of the station building of the proposed such and such is nearing completion, and corrugated tin shed is fixing in the side of the station. The land acquisition, land acquired by Metro Railway in the said claim case and possession handed over to in excess of the land under ownership of the claimant in CS Dag number 578. In this connection, the further joint survey is necessary, and as such, the modified site plan is prepared for site verification and herein submitted. The claimant herein further submits for necessary order for joint survey of the land in question of the in the said premises. Now, in the process, what I find, my lord, that the surrounding land Whereas in the compensation was paid in a similar type of land, they were treated as a malot the commercial land. By my land was not taken into consideration as a commercial one. So that was also the mistake that I pointed out by way of recalling. Court said, with the tribunal, a competent authority said that I don't have any jurisdiction to review either to rectify this error, because this is not an error by mistake. So on my own volition, that I don't want to enjoy the money of the public exchequer in excess, I am ready and with that is my pair. I am ready and willing to pay the entire refund back the entire money along with the 12% interest which was handed over to me. Kindly see the next paragraph, my lord. That was 6, and kindly turn to my lord.
Where have you said that you want to hand over the entire money?
My lord?
Where have you said that you want to return the entire?
Yes, kindly see. My lord, page 8, paragraph 8, 37.
Yes.
The claim case bearing such and such number, the manager allowed the instant claim being the landowner of the land in question hearing considering the nature of commercial. The land value was determined such and such case as per this the entire area such and such and interest till date delivered there. In such a view, the instant claim are also entitled to. Just a minute, my lord. That is why that case I am. Para? Yes. না ওটা তো ড্যামেজ না আমি যেটা জজ সাহেব জিজ্ঞেস করছেন আমি যেটা আছে আমি বলেছি লিখেছি না না আমি এটা বলেছি kindly excuse me for a minute my lord I'm just yes বলেছি no 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 my lord my lord I'm my lord incorrect to say this but I have talked to my client my lord they are ready and willing to pay the return back the money that is my instruction
For the balance portion.
The excess amount which has been paid to me.
But then the matter ends.
No, my lord, only cannot be end because I tell you, lordship, the way this has been done, a part cannot be allowed. If you allow, either you allow my application, rejecting my application, this cannot be done as has been held by the Supreme Court. Supreme Court.
Come back in 5 minutes.
Yes, yes.
So
The-
according to you, either they have to recalculate the entirety of it on commercial basis and pay for the entirety of it, or you will neither return nor take back the land. That is what I understand.
No, my lord. What I am on is this. My specific application is very candid in two-fold way. One is, look, the judgment will attend the finality, because at any point of time, Metro Rail did not prefer any appeal. Either against the rejection of this, my application, my lord, kindly pause for a moment over here. What would have been the fate? My application was rejected. Then I was enjoying the excess money. Metro Rail did not prefer any appeal against this order. Metro Rail did not prefer, accepted the position. No matter what I am on, I filed my application for recalling in twofold. That excess land measurement was wrong, remeasure the thing and find out the actual one, determine the compensation. Second, you determine the compensation based on the actual character of the land and pay compensation. Judge, competent authority said, rightly said, I must say, that I don't have any power to review or recall the review the order. Appellate authority said that invoking section 152, not section 151, although it was fallen earlier, fallen from your lordship, that 151 is a wider power. Supreme Court has deprecated that practice also. That in the guise of 151 or 152, you cannot correct everything. If there is a genuine omission or mistake in the judgment, that can be corrected under 152, not under 151. So, my lord, what I am on is this, that now while you are rejecting my application, saying that, no, your application is not maintainable, my respectful submission before your lordship will be this, but everything will go. There cannot be part allowed.
Then you will be allowed to keep the money despite less land having been acquired, and that should be
So what will be the correct state of affairs? Because kindly appreciate, my lord, this is me who approached this court.
very well. It is you. You did not go there bona fide. I mean, only for the purpose of philanthropy. You went over there for the purpose of revision of the compensation paid to you, so that you can earn more. The intention was,
it is not.
The intention
No,
was
my lord.
not only to point out mistake. Intention was to get commercial gain out of it. That is very right. There is nothing wrong in that.
No, my lord.
But then you cannot take advantage of the saying that merely because I have pointed out, therefore I should be allowed to retain.
So what are my point of considerations today before your lordship? That you recall without recalling the order in the guise the way you are going to do this, you cannot. That at the very outset, I pointed out to your lordship, my lord, this is to be considered by your lordship. Whether in the guise of this, without recalling the order, without modifying or rectifying the body of the judgment.
So you mean to say that in such a kind of situation, it becomes absolutely incorrigible. There is no way out for it to correct merely because
No.
Does not
I have never said
that
so.
151 has been deprecated by Supreme Court. 152 will not apply. Therefore, this becomes.
My lord, I am not saying so. I am saying that this can be done by way of recalling the judgment.
Under what provision will he recall? Show me that provision. That also has been deprecated by Supreme Court, saying that if there is no provision,
subject to your lordship correction, kindly like to draw your lordship kind attention to, if that be so, my lord, that wrong will continue. If that be so,
show me that
yes,
will continue at the
no, not on that. That is the interpretation of mine. Kindly see. Kindly allow my junior to place the judgment. So that, yes, ball. Aye.
1999. My lord, kindly comes to paragraph 6.
Paragraph?
Paragraph 6. 1999, volume 3, SCC, page 500. Paragraph 6. Section 152 of CPC provides for correction of clerical or arithmetical mistakes in judgments, decrees, or orders of errors arising therein from any accidental slip or omission. The exercise of this power contemplates the correction of mistakes by the court of its ministerial actions and does not contemplate of passing effective judicial orders after the judgment, decree, or order. The settled position of law is that after the passing of the judgment, decree, or order, the court or the tribunal becomes functus officio, and thus being not entitled to vary the terms of the judgments, decrees, and orders earlier passed. The corrections contemplated are of correcting only accidental omissions or mistakes, and not all omissions and mistakes which might have been committed by the court while passing the judgment, decree, or order. The omission sought to be corrected, which goes to the merits of the case, is beyond the scope of Section 152. Court cannot go into the merits under Section 152, for which the proper remedy for the aggrieved party is to file appeal or review application. It implies that the section cannot be pressed into service to correct an omission which is intentional, however erroneous that may be. It has been noticed that the courts below have been liberally construing and applying the provisions of Section 151 and 152 of the Code of Civil Procedure, even after passing of effective orders in the list pending before them. No court can, under the cover of the aforesaid sections, modify, alter, or add to the terms of its original judgment, decree, or the order. In the instant case, the trial court had specifically held the respondent state liable to pay future interest only despite the prayer of the appellant for grant of interest with effect from the date of alleged breach, which impliedly meant that the court had rejected the claim of the appellant insofar as pendency light interest was concerned. The omission in not granting the pendency light interest could not be held to be accidental omission or mistake.
Accidental omission, only that can be corrected.
My
If it
lord.
is intentional, it cannot be corrected.
My
So you
lord.
have to show that it is an intentional thing,
Intention.
that you intended to do only that. Only in that case, it cannot be corrected.
Yes, my lord.
Yes.
My lord, relevant portion is para 18. Section 1, my lord has got it. Para 18, Section 152 of the Code of Civil Procedure empowers the court to correct its own error in a judgment, decree, or
152 cannot
My
be invoked for the purpose of correcting
merit-
errors
yes,
which
my
are not committed by court
My
but
lord.
by parties.
My lord.
That is the ratio.
My lord, paragraph 18 to paragraph 24 is the relevant paragraph.
Others are all reiterations from judgments.
My lord.
The issue is only that.
My lord, only that one.
Paragraph 24 is the relevant part.
No,
Paragraph 24 is the ratio,
relay
is the
judgment relay.
ratio is only paragraph.
Only paragraph 18.
18 is the ratio.
So therefore, my lord, my respectful submission before your lordship will be this. Kindly contact the matter to the competent authority and we have my application pass it in order. Otherwise, my lord, if something is allowed to be written in the body of the judgment and operating pass is being corrected, possibly your lordship will not allow that. In the other part also, my whole intention is to correct the my lord. If he say, no, I am not entitled to have the compensation, I will not going to, so let him pass that order. But one hand you are saying you are not allowing the recalling application, which is a composite one.
Yes. What is your submission on this?
For the judgments are concerned, my lord, may I come back on any develop before that, my lord, the submission which was advanced
show me your power to.
Yes, my
correct
lord,
the
I'll come
record.
back. But just one thing I would like to point out.
He is my lord, the metro railway.
Very well. He will argue
Yes.
for that also.
But on the last occasion, I have submitted. Can you take the last order, 19 June, my lord? It was submitted, but that that in terms of the direction of the appellate body,
That is neither here nor there, because this is the main order. Those are only consequential.
consequential
If this
order.
order goes, then that will have to go.
Yes, but this was a direction of my lord that it has been submitted by a senior friend that an appeal shall be preferred in accordance
Very
with
well.
which
Even
will
if
be
it
merged with
has
this.
been preferred,
issue
not
cause.
preferred, whatever it is.
Yes,
If this order goes, then that is a dependent order. It has to go.
absolutely, my lord.
And if this order is sustained, then that will also be sustained.
Yes, but meanwhile, since it is in my humble understanding, since it has been passed a direction by the appellate court,
Since this
and the
revisional
executing
application
court,
this revisional application is pending, therefore merely because a consequential action has been taken, this revisional application cannot become infructuous because of that. That is not the law, because that is not independent of this order.
yes,
This
absolutely,
order
absolutely.
that is dependent on this.
Yes, yes.
So it has to abide by the result of this.
That is absolutely there, but it is an executing court has passed the decree in that sense, has passed further on.
Decree is not a decree.
If I consider this to be a final order.
Very well, that can be, that is amenable to the jurisdiction of this court.
Yes, my lord. Now, my lord, the submission which was being made by
The initial action itself is bad and is held to be bad. Then all actions on the basis of that initial action will be bad.
Right. It was my duty to point it out before your lordship, my lord. And the submission which was
Answer on merits.
made.
Answer on merits of this matter.
Yes, my lord. This is the deposition made by the petitioner before the competent authority. Well, on 10th of July 24, lordship kindly takes the third last paragraph. This is an admitted position that they are ready to refund the compensation amount as paid in excess.
Yes.
That is their own case, my lord. So, my lord, so far this revision is concerned, challenging the order that this was wrongly done, that the crux of the submission of the petition is, my lord, wrongly done, rightly done, whatever the case may be, will not, my lord, that cannot be entertained by the appellate court. So now, my lord, the jurisdictional issue, lordship may kindly take, my lord. Starts from, my lord, 15 of the Metro Rail Construction Works Act 1978.
Give me a direct.
And my lord, 16B also I'll capture. Yeah, gonna go to 15. Yes, my lord. 15 is the power given to the competent authority.
Yes, very well.
And one of the 16B, which is important. The law is very clear on this aspect, which is being challenged, my lord. It has got the power, the right of delegation, right of, my lord.
His submission is that under section 151, you cannot correct this kind of an error. This kind of an error is not only an accidental slip or an arithmetical mistake which can be corrected by the court. If the mistake was such that it was done by the court, then in that case, yet the court could have gone ahead and done it.
Yes, but
he has substance in submitting that the mistake was by the parties, not the court. The competent authority did not commit any mistake. Mistake was committed by the Metro Railway and by the petitioner in identifying a different plot. and measuring it so that the area remained the same, but the property differed.
Yes.
Now, in such a situation where the court has not committed any mistake, how can the court go ahead and utilize section 151 or 152 powers to correct a mistake that has been committed by you or the other party? Then in that case, the other party or you have to bring it to the notice of the court if there is any provision under the law going by which the court can correct the error. Otherwise, the error according to him remains incorrigible. It cannot be corrected. What is your submission on that?
Well, that on twofold submission. Well, the fact remains, Lordship, in that case, would invite you to Lordship to kindly take the joint inspection report.
That is factual.
Which was done.
Please answer the point of law.
Yes,
That
yes.
is factual.
I will
There
come
is-
to that. That so far the law point is concerned, the court has the inherent power. That is.
Then you are not getting the point. This inherent power cannot be exercised for the purpose of correcting something which is not the error committed by the court. If it is mistake of court, it can be corrected by court suo motu.
Yes.
If it is mistake committed by the parties that has led to the court committing a mistake, then in that case the parties have to approach the court through a procedure prescribed in the statute, following which the court has to correct.
Yes.
There is no procedure prescribed herein by which you can go. It has to be either by review or by way of appeal.
Yes.
You have neither preferred review nor preferred an appeal. How do you then correct it? In his appeal, he cannot be worse off.
It is pointed out by their application, seeking pointed out the admitted position of fact that this was in excess, and
right,
and thereafter
how do you
joint
get it corrected? Where is your authority to correct it?
Under 152 can be followed, my lord, here.
And 152 cannot be followed. You are not understanding the query of the court, sir. Please keep
My
your
lord.
mind cool and then try to understand what the court is saying. 152 can be utilized, or the power under 152 can be used for the purpose of correction where the court has committed the mistake. Is the mistake committed by competent authority? You had supplied right figures and he has written wrong.
It is the order of the appellate court. It is not the mistake of the court.
Sir, please answer
Yes,
the
yes,
question.
yes, yes.
You had supplied right figures and the competent authority has written wrong figure. Is that
No,
the
no,
case?
no.
So it is a mistake committed by both of you.
What is?
Whatever you presented before the court, the competent authority, that the competent authority incorporated in the order.
I understand. I follow.
Now, if the competent authority is not at fault, 152, 151 go out of question, is his submission. What is your answer to that?
May I come back on this issue? Because
When will you come back? Tell me.
Friday.
What is your urgency?
Urgency is, my lord, there. Please. Now on the basis of the direction passed by the appellate authority, competent authority is proceeding against me
For what?
for refunding me the money. So that can be stated.
That order is there.
So for the timing, that can be stayed.
I'll come back in 2 days' time, my lord.
For 2 days, that will be stayed.
Don't take coercive actions in the
Yes.
So, even that order has been passed, and this is not the question of recovery at this juncture since it is pending. My lord, let it be in 2 days.
So
I'll
if-
come back in 2 days. I'll come
So
back on
kindly,
Thursday.
sir, if-
Today is Tuesday.
My lord, I put it to myself, what is the harm? If this is no coercive steps can be taken, is it passed by for 2 days? For 2 days only. Kindly, they cannot.
They have admitted.
I will
Yes.
record this.
They have
that you
admitted.
Then should I
My lord,
record?
may I say one thing, my lord? This is the admitted position. They have decided, they have agreed to refund the money.
No, there is no admitted position. There is
But
no
I have
admitted.
just raised it. Let them deny, my lord, this is not their deposition in that case.
Kindly show the deposition.
But I have
If
already
that be
added.
so, kindly show the deposition where I have admitted. Show me the deposition where I have admitted. Third last paragraph, what I have said. I do not admit the correctness. Well, we are ready and refund the excess amount received by us by way of compensation. Kindly see. So what I am on.
The law
is this.
point remaining.
So
the
law
facts.
point is
It's
this.
a very
that
admitted
without-
position.
Mr. Pan, if you have already said that you are ready and willing to refund the compensation, this is your evidence. Then
Yes.
Coercive steps can they take? If you.
Madam, kindly see, madam, my whole question is this, that order itself is required to be recalled and modified.
Very well. Even
So-
if the order is not recalled or modified, you have
No.
since.
No, my lord, kindly, here, my lord, kindly, I join the issue. When this deposition was made, during pendings of my recalling application.
Let it be tomorrow in that case.
During my application, pendings of my recalling application, did
If your lordship diary permits, my lord, I'll come back tomorrow, my lord, in that case, my lord.
Come back tomorrow.
Grateful, my lord.
well, the whole intention is this, my lord, that
No question,
this
my lord. Sir,
deposition
admitted
was
for the
made
facts.
during the pendency of my application.
Whatever fallen from your lordship, we have followed, my lord, we will answer to that. Because factually, it is
Please
absolutely
please
clear.
answer on
Yes.
the question
Yes,
of law.
yes. we will, because I'll
Please answer on
see the
question of-
judgment cited by my lord, and senior friend also, and I'll answer to that.
Very well. Come back.
Tomorrow?
Yes.
Oh, my lord, kindly make it Friday. My lord, tomorrow I am not in town. My lord, my
I have no
person.
problem.
Friday লিখে
Can you make it? না তুই করে দিবি কালকে?
as
Position, my lord.
yes, it is there wherever it is.
Can-
Sign
can.
matters. If it doesn't, Mr. Chakravarti, please see that it's
I will. I
but there if
I
it's not called on so that
Yes, yes, yes. yes.
take his phone number, call him so that I can take it up. Both parties are there.
I have.
My lord, I'm appealing for the petition, my lord. On the last occasion, your lordship had was pleased to direct to serve it upon the opposite party number 1 and 2. This is my affidavit of service.
On that expeditious disposal.
My lord, my lord. The only problem is that they are not taking any step upon the pro forma defendants for the last 4 dates, my lord, because of which the matter is constantly getting adjourned in the lower court, my lord.
Very well. লিখে নিন. They have received.
My lord.
Picked up.
Lord, I am the petitioner, my lord, Miss Matter, my lord.
I am for the appellate.
Matter, my lord, part This is the third instance, my lord, matter is been
passed over, don't object. Yes,
passed over.
next.
Hoy, আজকে আর হবে।
Next.
Around 25 minutes I appear for WBCDCL. It's a matter, my lord, where the petitioner, my lord, they used to enjoy electricity, my lord, salary tube connection. Starting from, my lord, 2005-6, in this way they are going on. Every year, Lordship knows that there will be one agreement with the consumer. They will make an application and deposit for short term, my lord, for 3 months, 105 days connection. And against that, my lord, fixed amount is to be paid. In this way, they used to pay. And that was going on up to, my lord, 13, year to year, year to year, year to year. Then, my lord, thereafter they came to know that some amount has been paid in excess. These amounts were not, my lord, likely to be paid by them. They are paid in excess. Therefore, they started, my lord, making application. They refund the excess amount. Those matters, my lord, few matters came up before this court, and my lord, honorable court directed in those matters that Ombudsman to take a decision, because no quantum, what amount is to be refunded, that was not decided. Be that as it may, my lord, what I am also, my lord, the same point I'll have to place before Lordship for fresh consideration, if at all. I say, my lord, year to year they took connection. And my lord, Lordship knows as per the regulation, my lord, within 90 days from the date of cause of action, they should approach that as per the regulation. But if they come after, my lord, 7 years, 8 years thereafter, after they comes, my lord, I took this point, but that was not also accepted by one of the coordinate bench. I said the regulation say, whenever cause of action is arising, you approach them within 90 days. That's the regulation, Lordship. Regulation 56.6 says so. So, my lord, that was not followed. But in such circumstances, my lord, I will be placing, my lord, I will be submitting, my lord, Lordship, kindly apply your Lordship's, my lord, consensus, my lord, decision, what is to be done. Because if any...
There is a coordinate bench decision also
Yes.
holding the field, then in that
That
case,
is there.
how will I take a diversion?
Very well, as your
But
lord.
similar issues, my lord,
I have said that.
only in respect of, my lord, the quantum, my lord. All the delay and everything has been discussed in earlier, my lord, decisions by several decisions.
Very well, I will not take up, praise those seriously, my lord, those points, because since
Only
one
kindly, my lord,
coordinate
remand
bench
the
has
matter
decided.
to the, my lord, Ombudsman only on this issue of, my lord, the quantum. একটা copy আছে? এই তো।
In this matter also, my lord, there was direction that you should come up with an application affidavit.
Pass the same order then.
As your lordship desire.
will be forfeited. If this consequence is not provided, then this is not a
General application is this, my lord, you want to approach by this time. Why you have not approached?
time frame is said to be mandatory only if consequence is provided.
Yes,
If
other
consequence is not provided, then in that case that time
somebody
frame
may
is not provided.
give, but some explanation has to be
That
given.
is the settled. That is the settled law. Even in consumer forums, you know better.
No.
Consumer forum, this was the concept which was roped in by the Honorable Supreme Court in that top shoe line or whatever the judgment was, saying that there is a consequence provided, that your right will be forfeited. Not beyond that. That is not the language.
That is not the language, but
That
explanation.
was what was roped in by the Honorable Supreme Court in the case of Salem Bar Association for CP Codes Order 8 Rule 1, filing of written statement within 90 days said to be directory if you explain.
And also, my lord, subsequently,
Although the language there is a little more restricted than the one which is here.
and also, my lord, that has been clarified in the constitutional judgment of National Insurance Companies matter. But here, my lord, some explanation has to be given by the consumer. Why I am not approaching?
That is there. That
Otherwise, lordship, kindly, my lord, appreciate one thing. Floodgate will remain, my lord, open for everybody at any point of time.
I appear on
অত পেছনে যাবেন না।
I appear on behalf of WBSCDCL in this matter.
Is who is appearing for the petitioner? লিখে নিন। না না
Should I appear for the petitioner in this matter? But it's but the petitioner is a co-sharer in respect of a property at Salt Lake. But I am a young widow, and blood, there was blood a difficulty which I faced about blood the living in the property, and blood the property was serviced by blood a electricity meter standing in the name of my father-in-law. My other co-sharers, blood, the brother-in-law and the mother-in-law, blood, they were instrumental in blood disconnecting that electricity meter, and therefore, blood, the property where I was living, one of the floors in the Salt Lake building, blood, it got disconnected. So I made an application for a new electricity connection. In course of blood hearing of this writ petition, blood, it transpired that blood, one of the tenant in that particular building, Standard Chartered Bank, was in area of a particular certain sum of money. And Lord, for that reason, Lord, the electricity provider said that I cannot give you an electricity meter. Now, Lord, now that Lord, the problem with the Standard Chartered Bank is over. They have paid their dues, and Lord, there is no impediment for the electricity provider, Lord, to Lord, provide the electricity. Now, Lord, on the last occasion, Lord, pursuant to the direction of my lords, Lord, there was Lord, a report filed by the electricity company, Lord, which said that Lord, there is Lord, another Lord, a small due of about Lord, কত টাকা রে? 6,000 টাকা।
No. At present, 18,000 right now. At present.
Very well. Lord, 18,000. Let us take it from Mr. Shahara, it is 18,000. So,
At
Lord,
present, up to 12th of June 2026. I don't know whether it has been extra. It may be minor, something, not like that.
meter নেই তো বাড়বে কি করতে?
No.
Anyway, Lord, whatever that is not there, Lord, my client is willing to Lord, pay that amount as a precondition of Lord, fixation of the electricity.
Yes. We are ready and will. Lordship, what happened? I tell you. What I mean to warn you. What happened? Lordship, kindly allow me for a moment. But there are basically 2 meters.
now they are ready and
Now,
willing.
yes, we are ready, subject to compliance of all. For the meter is lying in the name of a dead person. So,
correct.
subject to compliance of all formalities.
First of all, my learned friend made a submission that the mother and the elder son were instrumental in disconnection. That is a wrong statement. But the application has been filed upon suppression of fact. What my learned friend's client could not get through the civil court, this is the other way round process trying to establish her right. She has
This
filed.
electricity connection, madam, will not give him or her any right. That is settled. But since the person is in settled,
lock and key, and there is a status quo order.
Status quo order will not stand in the way of grant of electricity. That is not disturbed by.
Lord, your lordship will look at the application made by my learned friend. He has said
if the person is in possession of the property,
he is not in possession. That
the WBSCDCL authorities will consider. If the WBSCDCL authorities find that the person is in
they
possession
have
of the
said
property,
they are
they will get it.
occupying the property
That is
under lock and key.
I may occupy and keep it on lock. I am not required to be there 24/7.
That is.
Requirement. There is an order of status quo from the lower court as well as this high court. There is a probate.
What is the finding of the status quo order? That he was not in possession?
No. Page 117. 17A.
Nature and character will not be changed. Possession, if he is not found to be not.
It's not there. It was under lock and key.
That has to be found by the trial court.
Contesting the probate
Madam,
proceedings.
if the trial court has not come to a conclusion even prima facie that the petitioner, that prima facie, that is why I am saying that the petitioner is not in possession of the property and he is able to show by evidence aliunde to the
to show that first.
That will be the outlook of the
And
WBSCDCL authorities. I cannot.
By your lordship, my lord,
I will
on
not
that day
interdict
there was
here.
no electricity connection.
Very well.
Never. Electricity never creates
absence of
rather
electricity
statutory right.
connection will not prevent a person from being in
Was
possession
not
of a
there
property.
Deciding there.
That will be the out. Madam, I will not preempt this decision. This is a decision which is to be taken by the electricity authorities, whether they are found in possession, whether they are found in possession or not. If they inspect, they find him in possession, they will give electricity supply.
But rather, if your lordship sees 17A of the writ petition, Lord, the injunction order that I got in the partition, Lord,
is 17A.
17A. Both the plaintiff and the principal defendants are directed to maintain status quo with respect to the nature, character, and possession of the scheduled property. Therefore, my learned friends, Lord, argument, Lord, that this belies, Lord, my case. This is in my suit.
Your Lordship, I am for Standard Chartered Bank, Your Lordship. I want
Yes,
to
you have
submit-
paid. You have paid the dues of.
No, that is my point, Your Lordship. Kindly take this chart, a small chart.
You haven't paid.
No, no, no.
Then you
Tell-
pay.
I'll tell you, Your
ও
Lordship.
বলছে pay করেছে, তুমি বলছে pay
No, no, no,
করোনি।
it's not like that, Your Lordship. Give me 2 minutes.
Pay.
I have made the payment. They are saying they have deducted it from my security deposit, Your Lordship. So in this chart, I'm giving copies to the parties, Your Lordship.
Yes.
So basically, if you come, firstly, we as Standard Chartered Bank have exited the premises in August 31, 2022.
Yes.
Then the electricity bill was disconnected by WBACDCL on February 2, 2023. The issue was they could not remove the meter because of the dispute between the parties, Your Lordship, and I am not in the premises to give them the lock and key to remove the meter. So if the meter is not being removed, some minor charges are being incurred. Now Your Lordship comes to Annexure A, the next page. If you see that, at the very end, it's written outstandings rupees 267,686.36 from November 2022 to August 2023. This is a September 2023 bill. SCB has received this bill, Your Lordship. The consumer ID is in my name. Your next page, Your Lordship.
No, he has to file the separate application. On that basis, I will take the instruction.
What do you
Let
want?
me
What
finish
do you
my
want?
submissions. The next page, Your Lordship. Let me show you the facts. Kindly allow me to make my
Just tell me the prayer first, then we'll go to the facts. What do you want?
I have been implemented by them by an application can one. I don't have a copy of the writ petition also, Your Lordship. The only issue is with regard to the meter they were not getting because the meter could not be removed. Just next page, I'll
Orderটা বার
Order
order কর orderটা বার কর আমি দেখি
page 30th January 20.
Distributor service are everything
Letter to WBACDCL asking them to adjust the sum I showed 267,686 to be
Security deposit.
yes, from the security deposit, which was 374,319, more than the amount. Now, Your Lordship, this year around February, WBACDL's advocate came and said, we have not received the letter. So I have the receiving is on the top, so 31st January 2025. Now they have given a report, Your Lordship, which shows the report is in page 7 of this chart, Your Lordship, which shows into Greenless Bank there is a due of rupees 397,998. Your Lordship, I am not in the premises. I have given them the liberty to adjust it from my security deposit, which is more than the money. Will it be fair on Standard Chartered Bank, Your Lordship, to deduct now at present?
But madam, your writ petition is not there before the court. If you have a grievance, you have to come up against WBACDCL by way of another writ petition. On his writ petition, I cannot pass order on your grievances.
He is not even giving me the amount, how much he has deducted.
That you
that
take
is
up
fine,
the ask time. The writ petitioner here has come that because of your dues, he is not getting supply. I will direct giving supply to him, but that will not prevent you from challenging the WBACDCL's demand.
Yes.
If you are aggrieved by the demand of the electricity authority, you challenge the demand, raise objection to that.
I reserve my right, but I am not opening my mouth right now.
The writ petitioner's writ petition does not pray for any relief against you.
Agreed, Your Lordship, but now I have been made a party in this writ petition on the basis that my meter was pending. They are saying they have removed my meter.
Not your meter was pending. There were some outstanding demands pending.
But there is no, this is an outstanding, there is no due certificate. এটা to দিদিন তো এটা to দিদিন
Certificate, Your Lordship, I have been handed over right now. There is no mention of how much he has deducted. Can he arbitrarily deduct some amount and not give details?
Take it. I cannot decide this here.
But
In
this
their
is
writ
part of
petition,
the
how
order,
can?
Your Lordship.
No,
What
in
will I
this
pass? You
petition-
tell me what order will I pass? Will I decide that there is no amount due?
No, Your Lordship.
Then why are you making this submission? We are unnecessarily wasting time, nothing more, because I cannot adjudicate on whatever your grievance is. You are not the petitioner before the court. You are the respondent who has been arraigned by him. He may not like you to be added as the party. He may want you to be added as the party. If we have something to say against him, very good. But if you interplead amongst themselves, then it will be an interpleader suit.
At least in that case, something with regard to he must at least make the submission before this court, how much he has deducted.
But so far, we have got no due certificate. I have procured that no due certificate, and the how much is
I will
deducted.
say that they will
If they have any grievance,
intimate they
yes,
have given you no
let
due
them write a letter.
Please wait, Mr. Dr. Sahara. I will give you liberty to write to them saying
Yes.
that how your security deposit had been adjusted, and if you have any payment dues from them upon adjustment, that will be refunded. You will be entitled to claim that. And if they have appropriated the amount after the adjustment, although it was due and payable to you, then in that case you have your remedy against them.
But can it be specified in this matter subject to
Because
lordship
she has
kind
made
of approval?
submission, at least I'll have to make that observation.
But I am putting to
justified.
that in this written, she cannot sought for the relief, lordship.
Not granting any relief.
I am objecting that.
No, your objection is overruled because I'm not granting any relief. I'm only recording her
Only to the petition.
Only at that. And
Her
subject
submission, she is entitled to make her submissions. I am
of
entitled
course. citing the Obhimanyu Majumdar case here, you know.
No. That is for
2010,
settled. Justice Joyanto Biswas's judgment is the first, I think, in point, 2010.
Oh,
occupant.
I appear on behalf of WBCDCL in this matter.
ECDCL. লিখে নিন বসেই লিখুন এটা ছোট none appears for the petitioner petitioners প্রেজেন্ট ছিল অপোজিট পার্টির সার্ভিস এখানে ঢুকে গেছে কি করে নেব এগুলো পুরনো ম্যাটার নিচে চলে গেছে হিয়ারিং ম্যাটার গুলো উপরে চলে এসেছে কি করে দেখবেন যেরকম এই ম্যাটারটাই সব পেছনে চলে গেছে
My lord, 29, my lord, here, my lord, the writ petition here, the whether the transmission company will draw the my lord overhead high tension line, but without due process of law or not here. But my lord, here, my lord, transmission company notified that only the Mousa has been mentioned in the notification. There is no mentioning of the plot. Well, immediately, my lord, I moved the civil before the civil court. With the civil court, my lord, I pray for my lord not to draw. But my lord, it is drawn.
tomorrow yes
My lord,
Then but this matter is not today. For
my lord, I want to mention a two writ petition to file. क्योंकि mention एक time देखिए 100% डाक्टर सकाले
sanction of interim order. I've got my other side. The matter is fixed tomorrow before the court.
Yes, yes, yes. The same thing will be there. Same order. The order
till today, let it
is
let it
30th
continue.
of July. It should.
My lord, item number 37, we have received fresh notice from the respondent that they are going to take poison within 30th July. Lordship,
ওই এনাদের এগুলো অনেক সময় লাগবে তো ওনাদেরকে ছেড়ে দিন না 81 হ্যাঁ
my lord, item number 37.
81.
Lordship, one. My lord, I was just praying, my lord, if they can wait for, they may get their turn. It's in the list, your
we will
lordship.
be limiting it. It is not going to be for unlimited period.
I don't want to.
Because yes,
The moment it comes for extension, you remain.
Yes.
only Mr. Banerjee was on rejoinder and he said that it will take only 15 minutes. That's
No,
why.
no, no. That can't be. I
Well,
can't use some another.
That was in the last order.
This is not a determination. I can't do that.
That was
না
in the,
অর্ডারটা দেখিনি কি আছে
that was in the last order of your lordship.
লিখে নিন just be for a limited period till such
Yes,
time
yes,
the
of
regulation joins. Having heard the for the respective
This is item number 19 of yesterday's.
সময় বলবো তো মেনশন হ্যাঁ তাই করুন ঠিক হ্যাঁ
Both side has.
Your Lordship, this was item number 19 of yesterday's list. It was taken out of turn, Your Lordship. I was waiting here till 4:30, but the matter was not taken up, and then out of turn that was taken up. Item number 19. I was appearing for the borrower. Can my name be recorded in the order, Your Lordship?
Not my turn, my lord.
the petitioner was there petitioner argued
My lord, in short, suit for partition of two flats. There are, my lord, 4 co-owners. Preliminary decree passed. Appeal filed before this honorable court. Preliminary decree, my lord, upheld. Final decree, my lord, was about to be passed when the partition commissioner was functioning. My learned friends moved a section 151 application. That was rejected. From that rejection, Article 227 petition was filed. In sum and substance, in the Lord 151 application is, I have paid a lot of money in respect of the flat, so therefore it should not be partitioned. And Lord, against that rejection, they've come up. The argument made before your lordship is that I have paid off the bank, so therefore I stand subrogated in place and stead of the original mortgagee, and I have rights. Number 2 is I have spent payment, I have made expenditure in this property, so it should not be partitioned. This is the situation. Yes, yes. No, no, not at all. Lord, your Lordship, my Lord, sees the impugned order once against which, my Lord, they've come up. Kindly take, my Lord, the second volume. But on the first day that it was moved, there was, my Lord, a little paucity of time. The learned judge said this must be considered. So let the report not be given effect to. We have always agreed to, my Lord, extensions. Matter has to be heard, we agreed. Now please see, my Lord, the impugned order of 22nd December. I think that was the last day. Now kindly see, my Lord, the first page. Yes. Before delving into the matter on consideration of both the above mentioned application of merits, it would be relevant enough to go through the history of the case. Title suit was filed by plaintiffs against defendant Murari Kejriwal. During pendency of the suit, Murari Mohan Kejriwal died, survived by Sudha Agarwal. Suit was contested by defendant number 2 by filing written statement. Suit was disposed of in contested format with delivery of judgment declaring half shares. Then appeal. Decree was sustained. Now, my lord, please come to paragraph 7.
Para 7.
Yes, my lord.
Yes.
On 29th September, 20th September, record was put up at the behest of the plaintiffs in the event of making prayer for modification of preliminary decree. And then 24th September, record was put up again. All of this happened. And then please see, my lord, commissioner is asked to immediately proceed because in this case, there are, my lord, at least 3 High Court orders directing expeditious disposal, Supreme Court order, plus an order in criminal contempt, which we filed against them because they filed 52 interlocutory applications. Wanted to delay. Some very serious directions were given. They were compelled to, my lord, complete hearing. Advocate was asked to file an affidavit to apologize to the learned judge and pay costs. Now this 151, my lord, comes up for consideration. My lord, please see the third page. By referring to the decision of the Supreme Court, learned advocate on behalf of the applicant argued that unless liability is attached to the estate, that is suit property is ascertained, there is no legal scope to draw up final decree. So number 1 point, liability is attached to the estate has to be ascertained. Number 2, submitted that in course of trial, relevant documents would show liabilities attached with the suit property. However, concerned learned trial court did not find it appropriate to deal with the matter. Observation was made in para 82 of the judgment. Learned advocate also submitted it has not been brought to the notice of the court that suit property was mortgaged for obtaining loan and ultimately led to a situation where the matter went up to DRT, and it is the defendant number 2 who took all steps apart from clearing of the dues all by himself alone to release the property from the liability of mortgage. And as such, the co-sharers are indebted to this defendant. Drawing the attention of the court to the decision of the Supreme Court in such and such, argued that defendant number 2 as co-mortgager pays off the debt to the bank for the redemption of mortgage, and as such, before allotment of shares to attain final decree, the liabilities attached with the suit property is to be ascertained first. Learned advocate further submitted that in this case, by operation of law, defendant number 2 subrogated himself to the right of the other mortgagors in respect of the suit property in the matter of redemption in view of section 92 and 95. So, my lord, this is his argued case. And, my lord, the findings are on the next page. Middle of the page upon hearing, then. Moreover, second last paragraph. This court is also of the considerable opinion that here in this case, nowhere from the material on record referred and relied upon by the defendant number 2, it is being revealed that the matter of such claim is made at the stage preferring section 151 application has been raised either before High Court in appeal or that the defendant has liberty to proceed with the matter. Then overall consideration of the scenario, court is of the opinion that the application preferred on behalf of defendant number 2 not tenable under the present scenario, and in the background facts and circumstances of the case, unless liberty is obtained, you can't reopen, plus other High Court matter is pending. Yes, and below my learned friend is right. One more
view of the learned court was that since the matter is already before this court in some other proceeding, therefore he
correct.
cannot raise
That
it
is
there.
the paragraph I missed. Now, my lord, your lordship has seen their arguments in the 151 application. My first point is this argument of redemption of mortgage is beyond pleading. For that, my lord, I want to show your lordship 3 things. Number 1, written statement, page 41 of the petition.
Mr. Chaudhary, just for the sake of
Yes.
understanding, did this occasion of getting the property freed from mortgage arise after the written statement was filed or prior to the filing of written?
I think after.
Then
amendment. Then amendment. Evidence. Evidence continued till this year. So, my lord, I'll just indicate the points first.
No application at any point
Nothing.
of time prior to evidence.
Nothing. There is not a document even today which will show that he's got redemption of mortgage.
This 151 application was
also doesn't have it. even in the supplementary affidavit filed after the 227 petition, there is no document save a deed of gift by me to my son, where I have said that that the mortgage has been cleared, which was on incorrect, my lord, appreciation of the
No,
fact.
but was it that you said that the mortgage was cleared by them, or it has been
It
cleared?
has not been cleared. We have understood. We were misled earlier.
No, but in the deed of gift that you refer to,
Yes, I have said.
that it has been cleared by them.
Yes, yes, whatever clearance that has been done by them, there is no problem there. There is no problem there. That is his obligation as per a family settlement. So I expected him to finish it, and I made the deed of gift. But as it now stands today, there is no redemption. He doesn't have the title deeds with him. He doesn't have a single document from the two banks, and nothing is before your lordship today. It's not even open for him to argue. That's number one. Number two is, if I assume him to be correct, we'll have 5 points. His case of redemption of mortgage is beyond his pleadings.
Just.
Number one. Beyond pleadings, beyond evidence. This is, after all, arising out of a suit. So beyond pleadings, beyond evidence. Second, beyond 151 application also.
Then what for was that 151 made?
Well, a simple statement to save the property. That's not, my lord, redemption of mortgage. I just show one sentence. Third, no proof disclosed even today. Fourth, and this is interesting. My lord, let's for a minute, my lord, assume he's correct. He's got redemption. My lord, please see 2 sections of the act. I'm I should have opened it. Section 91, my lord. I'm sorry, my lord, 91 and 92.
91 and 92.
This does not make him a mortgagee. Let me read 91. Persons who may sue for redemption. Besides the mortgager, any of the following persons may redeem or institute a suit for redemption of the mortgage property. A. Any person other than the mortgagee of the interest sought to be redeemed, who has any interest in or charged upon the property mortgage, or the right to redeem, or upon the right to redeem the same. B. Surety for payment of mortgage debt. C. Creditor. Lord, amendment হয়েছে নাকি? না. Lord, may I read, my lord, 91A once?
Yes.
My lord, the bracket ends with redeemed.
Redeem the same, yes.
Who has any interest in? It's the same in the latest book.
Any person who has any interest in.
Yes.
This is a 2020 book.
Oh, the co-mortgager is in 92. That's fine. Right. So, my lord, these are the 3 people who can sue for redemption. 3 classes. Apart from the mortgagee, any person having interest in the property, really. By A, B, and C, anybody who has interest in the property, apart from the mortgagee, everybody can, my lord, sue for redemption. A, B, and C. Now, my lord, come to 92. This is what he relies upon. Subrogation. Any of the persons referred to in section 91. So, any person having interest as per 91, other than the mortgager. So, mortgager can never claim subrogation.
Of course not, because it is to step in somebody else's shoes.
Yes.
He himself.
Yes, he can't step into his own shoes.
He's wearing his shoes.
Yes,
has
so he
not
can't
taken
change
out-
shoes.
He has not taken it out.
Yes,
Somebody else to step in.
yes. So any person, but a co-mortgager can. Here, my lord, he'll be co-mortgager. Shall, on redeeming property subject to the mortgage, have So far as regards redemption, foreclosure, or sale of such property, the same rights as the mortgagee whose mortgage he redeems may have against the mortgager. So, if a I will not make it shorter. If a co-mortgager redeems the mortgage, what he gets is the same rights as my lord, same rights, qua redemption, foreclosure, sale, as the mortgagee whose mortgage he redeems. So he is pushed, he doesn't become a mortgagee. He gets the same rights of a mortgagee. Now, mortgagee, my lord, has two rights, foreclosure and sale. So by subrogation, though you don't become mortgagee, you get the right of foreclosure and sale. That's all. If I, my lord, have right of foreclosure and sale, then what can I do? I can file suit for enforcement of mortgage for foreclosure and sale. Has he filed a suit? No. So this whole argument ultimately won't get him anywhere. He, my lord, doesn't become a mortgagee. There's a Supreme Court judgment on that. My learned friend, my lord, found it. Lord, please see this. Lord, paragraph 7.
Paragraph 7.
Paragraph 7. But these rights in equity, either in favor of the person who discharges the debt or the person whose debt has been discharged, do not result in resumption of relationship of mortgager or mortgagee. Even under subrogation, a legal concept meaning substitution applied on English law principle even earlier, inserted now as under section 92 in Transfer of Property Act since 1929, the rights that are created in favor of a co-mortgager as a result of discharge of debt, so far as regards redemption, foreclosure, or sale of property, same right as the mortgagee whose mortgage regime. What is the meaning of the expression right as mortgagee? Does a person who in equity gets subrogated become mortgagee, or his rights are confined to foreclosure or sale? A plain reading of the section does not warrant a construction that the substitutee becomes a mortgagee. The expression is right as the mortgagee and not right of mortgagee. The whole legislative purpose was statutory recognition of the equitable right to hold the property till the co-mortgager was reimbursed, and not to create relationship of mortgager and mortgagee. The section confers certain rights on co-mortgager and provides for the manner of its exercise as well. The rights are redemption, foreclosure, and sale. I think that's not enough on this. So what right does he get? He gets right of foreclosure and sale. So, nobody who has a right of foreclosure and sale, or even a mortgagee, can sit at home and waive that right. He has to file a suit to exercise that right. And he's chosen, not to file that. Second,
yes,
if you have a right, this struck me now while arguing. I have seen these judgments. I will bring them and file them, give it to my learned friend. I'll have to find them. If, my lord, there's a mortgage stated in my favor, if I make a money decree, I lose my right in respect of the property.
there was this line of judgments. In this case, he's made money claim. He lost his right to the property. Because suit for foreclosure sale, first prayer is, my lord, declaration that money is owing. Then, my lord, is foreclosure and sale of the property by final decree. And I remember this issue used to come up if mortgage property was situated outside jurisdiction, we would write suit for foreclosure and sale. But when the client would want to do it in court, we would only make it a money claim. And my senior once, I had gone to him with one such plaint, he told me, well, you're being clever, but by your cleverness, your client is losing his mortgage right. Then I'll find the judgment, Milord. So, Milord, it doesn't really need to stretch that far. So, assuming he's, Milord, redeemed the mortgage, he doesn't have anything to stop, Milord, partition of the property. And mortgage, Milord, will run subject, Milord, to the partition. It's a covenant with the property, it will run.
No, but if he has redeemed it, then there is no mortgage.
If he's redeemed it, then no, his alleged right of having same rights, that right will remain. It's on the property. Now, Milord, this is to, Milord, deal with the argument. Let me quickly, Milord, go back to point number 1. First is, Milord, kindly quickly, Milord, see, because this is after all a partition suit. Everything has to be pleaded, evidence has to be before the court. You can't, Milord, add documents in 227. Milord, please have a look at page 39, at page 41. Para 5, page 41. He says, my lord, this is his written statement. Property cannot be partitioned.
What is this document?
This written statement. Written statement, my lord, starting from page 39.
Didi, flag the neck.
Milord, 39 at 41. Milord, para 5.
Para 5.
Second last, Milord, line of paragraph 5. First scheduled property has been mortgaged to the bank, cannot be partitioned unless mortgage debts are paid. So, Milord, written statement cases, mortgage has not been redeemed. Then, Milord, there is an amendment. Please, Milord, come to page 53.
Amendment of the
amended written statement.
The alleged redemption was done prior to this amendment? No.
No, Milord, the allegation is vague, so no date is forthcoming. Milord, this is an additional written statement. I'm sorry, Milord. In the additional written statement, please, Milord, come to paragraph 7. Page 54.
Paragraph 7, page 50.
This is Arsil coming in. And he says, Milord, at page 55, fourth line, present plaintiff along with defendant number 3 has not only consented to, but have left no stone unturned to ensure that not only flat number 3A, but also the other flat which is not mortgaged with PNB is sold in recovery proceeding. It is only defendant number 2 and defendant number 1 who are all along resisted, opposed the wrongful and illegal action of the bank.
Which portion are you reading?
Milord, paragraph B.
Paragraph B.
Yes.
Divorce orders.
Yes, Milord, towards the last 4 lines. He's, Milord, the defendant numbers 2 and 1, they have...
It is only the defendant number 2.
Yes, Milord, and the original defendant number 1 who are all along resisting, opposing wrongful and illegal action of the bank and orders.
Yes.
And he goes on, giving history of litigation, and he has deposited some money and sale was stayed. He says, I have deposited sums pursuant to the orders. Appeal is still pending. And he goes on. But, my lord, what is telling is there is no statement here that there has been redemption of mortgage. Redemption, my lord, your lordship knows, my lord, there has to be NOC, there has to be release of the property, and bank, my lord, has to redeem the mortgage. Yes, RCL was to be, but whatever, RCL has to be made a party, is right, my lord. That also, my lord, is a complication. Now, my lord, please see page 97. This is evidence of defendant number 2.
Page 97, yes.
Page 97. At 98, para 8B, and my lord, 98, 100, he just says that this was mortgaged, RCLs come in, etc., etc. There is not a single sentence on redemption of mortgage. You know, he said he's contesting, he said he's deposited some money, he stopped the sale. He said a lot, but he hasn't said anything about, my lord, redemption of mortgage. Important, my lord, is page 116. Yes, my lord, page 1015. I'm sorry, I missed that. I wanted to be fast and I missed.
101.
101, I say that the first scheduled property being mortgaged and the proceedings in respect of the same are still pending. Schedule 1 property cannot be partitioned unless the proceeding in respect of the property is disposed of. Then, my lord, at page 116.
Yes.
This is defendant number 2, Mahesh Kejriwal's evidence. So he says at page 118, he's paid the maintenance, property tax, my lord, paragraphs 10 and 11. Electricity, page 119 as well. But so his case is he spent money on the property. It's a different matter. This was our house, he threw me out. So you've enjoyed your spend. That's a different matter. But there is no statement that it's not mortgaged. To the contrary, my lord, para 14, page 120. Paragraph 14 starts. There's again, my lord, a story about sale of property. But important, my lord, is fourth line from the top, page 121. At the end of the line, though the entire dues have been paid off, the banks did not issue NOC. The title deeds of the suit property are still with the bank. All legal expenses, lawyers, fees have been paid by me alone. And this is, my lord.
This is what document?
This is the affidavit of evidence of the defendant number 2.
This is in the
24. This is 24. So till 24, his argument is he's paid off, my lord, the bank, but title deeds haven't come in because banks claim more. Whatever, that's his problem. But this is what he's done. Now, Please see the section 151 application. 187. Right? 187. Now, my lord, please see what he says.
187.
Yes, my lord. This is the 151 application. My lord, volume 1. 2, I'm sorry, my lord, volume 2. And from the rejection of this, he comes to court.
Yes, 187.
So third line, he says petitioner's right of subrogation at page 187.
Yes.
And he goes on. Paragraph 11 at page 190. Your lordship will find the sentence on perusal of affidavit of evidence and supplementary evidence. Specific case of the petitioner, petitioner has paid substantial amounts for preservation of the suit properties and to ensure that the suit properties were not sold off in the recovery proceedings. And he's quantified how much he spent. And my lord, kindly just quickly see paragraph 18, my lord, at page 199. The petitioner has paid a substantial amount to preserve the suit properties and to redeem the mortgage of the suit properties mortgaged with the banks. In view of the provisions of the TP Act, your petitioner, having redeemed the mortgage of
Page
the
199.
Yes, my lord.
Page 199.
199.
199.
Para 18.
199 is para 32.
Oh, I'm sorry, my lord. It's 194. The 4 is written like a 9. I'm sorry, my mistake. Paragraph 18.
194. Yes, paragraph 18.
Yes, my lord. The petitioner has paid a substantial amount to preserve the suit properties and to redeem the mortgage of the suit properties mortgaged with the banks and or financial institutions referred to above. In view of the provisions of the TP Act, your petitioner, having redeemed the mortgage of the suit properties, has stepped into the shoes of the mortgagee banks and is entitled to receive such amount proportionately on the basis of the shares of the parties in the suit. So this is his right of subrogation. So we have money claim. Please, my lord, note this, it's money claim. He says, and is having stepped into shoes of mortgagee, he is entitled to receive such amount proportionately. And this is his perceived right of subrogation. Then, my lord, and also when redeemed, how redeemed, nothing, my lord. One sentence. Now see the next page, my lord. Page 195, para 23.
Yes.
Your petitioner states that the suit property, being the 2 flats, are mortgaged with 2 banks. As per family settlement dated such and such in point number 7, it was agreed by all the parties that liabilities of PNB at present Arsil and Indian Bank, including legal charges, would be paid jointly. Then, my lord, his whole history. But nowhere does he say when he got the mortgages redeemed. Then paragraph 28. I'm sorry, 27. He says that I was aware of the banks of the subsisting mortgage. And then para 28, he says that no final decree ought on the basis of the shares declared by this learned court as modified by the High Court can be passed without first taking into account right of subrogation of your petitioner in the suit property as well as charge of the petitioner over the suit property. And then, my lord, next paragraph. As per report of Commissioner of Partition will ultimately have to depend on the entitlement of the parties in the suit properties after adjustment of the money that is due and payable. It is expedient to determine and adjudicate the amounts that are payable by the plaintiffs and the defendant number 3 to your petitioner on account of redemption of mortgage and on account of the charge that petitioner has. Unless this issue is first determined and adjudicated, a report filed by Commissioner of Partition will be of no avail. And next paragraph, it is humbly submitted. Learned court should be pleased to determine and adjudicate as to what amount is due and payable by plaintiffs prior to division of the property by meets and bounds. Then, my lord, please see the prayer at page 200. At the top, Your Honor would be graciously pleased to determine and adjudicate as to what amount is due and payable by the plaintiffs and the defendant number 3 to your petitioner prior to division of the properties. And if it is found that any more amount of money is required to be paid, to direct the parties to bear and pay in accordance with preliminary decree. So he says, I have a money claim. He goes to court. If I may summarize his position, he says, I have redeemed. Doesn't give a date, doesn't give a time, doesn't give a document. Then he says, I have not redeemed. I've shown your lordship that paragraph. So contradictory statements. And he says, I have a money claim. I have a charge over the property. I don't know where he gets a charge from. He says, I have a charge over the property. But I have a money claim. He goes to court for determination of the money claim. So this is what he goes to court with. Now the important thing is, number one, the petitioner has filed numerous proceedings for recovery of the same amount, prior proceedings. Which is why the learned judges said, you have gone to High Court to recover this amount, you go there.
Milord, proceeding there also stand is the same, that it is
Same.
redemption.
Milord, I have annexed, Milord. Amount same, particular same. So first, claim for expenditure in respect of the premises. This is the subject matter of CS number 377 of 2013 filed in this court.
Page.
Milord, plaint is at page 52 of written objection. Our written objection to 151, which we have separately filed. Milord, we have given with annexures.
Yes.
Milord, page 52 of our written objection is where the plaint is.
Page 52.
Page 52. Milord, this is CS 377. Now, Milord, paragraph 11 is the family settlement. So this is his case, Milord. Paragraph 11 is family settlement. Then he says, paragraphs 19 to 23. He says, by reason of the family settlement, both of us had to pay. Then paragraphs 19 to 23. This is, Milord, his pleadings regarding the expenditure. 50% of paragraph 19 at page 64, common maintenance account, property tax, municipal rates, and he gives me lot particulars at page 65.
Page 65. Yes.
65, my lord, he gives particulars. So this is expenditure, property tax, municipal rates and taxes, electricity expenses, internal maintenance carried out in the flat, monthly subscription to Radhika Apartment Ownership Association, including medical expenses of the father. Now, my lord,
But these don't include mortgage debts.
no, not mortgage. So, my lord, in the petition, he says, I have spent money on the flat. I have spent money to redeem the mortgage. This is first part. I'll come to mortgage in a second. My lord, for this, my lord, page 67, he's issued demand notice on me. The demand notice, my lord, is dated 27th of August 2013. Then, my lord, page 70, my lord, is the money claim which he makes.
Page 70.
Page 70.
Yes.
So this is the claim and this is on indemnity. And my lord, I'm sorry. My lord, my learned friend is right. My lord, kindly, my lord, also open the petition at page 190. The 227 petition.
190.
Yes, my lord. Because I'm going to match, and this is the 151 application, and this is equal to. Correct. So, my lord, the reason why I showed your lordship
190 is to be matched with
190 will match with page 80 of written objection. This is the demand notice issued by Mr. Kaushik Banerjee, dated 27th August 2013.
Yeah, just a moment. Page 190 of the revision. With page 80 of the objection.
Yes. Now, my lord, and this is referred to in the plaint and is part of cause of action. This is referred to at page 67 of the plaint. Lord, please see page 67 of the written objection.
Page 67.
67, this is, my lord, reference to notice of 27th of August 2013. That notice starts at 78. This demand notice for the amounts claimed in the plaint, 78. My lord, please open 80 and my lord compare with page 190. First, my lord, January 2008 to April 24, Kolkata Municipal Corporation. And then, my lord, again Kolkata Municipal Corporation, then electricity, January 2008 to April 24, my lord, page 191 of the petition. My lord, this is, in fact, it's easier to match from page 82 of which is the schedule to the letter. So, my lord, page my lord, here, if your lordship sees property tax at page 82, if your lordship sees property tax, SSC number such and such, And the period, my lord, at page 190, your lordship will find January 8 to April 24.
No, but this letter was of 2013 something.
Yes. Suit was filed then. So this is up to 13. And then if your lordship turns over.
There are other charges also like this.
Yes, yes, for the same genesis.
Amounts paid to Indian Bank, then RCL and all.
Yes, yes, yes. So, my lord, it's up to the date of filing. After that, it has to be updated. When that suit comes to trial, he'll have to update it and amend his plaint. But importantly, on this cause of action, he's filed a suit. Now, my lord, the second proceeding is an arbitration. My lord, paragraph. So, if your lordship opens the 151 petition, paragraph, page 190, paragraph 11A to 11D. That's expenses. So KMC, A and B are KMC, C is electricity, and D is apartment owners. These four, your lordship will find at, my lord, page 82, which is schedule A to the letter, property, electricity, Radhika Association, Radhika Association. Amounts will not be the same because the period is different. I'm saying the one is more updated. Now, my lord, please see page 191. E to H. This is money paid to Indian Bank to prevent sale of suit premises. E and F to Indian Bank. G to the mortgagee banks. RCL. And on the next page, H is legal expenses. So this is his claim. Now, my lord, please see page 109 of the written objection. This is an arbitration which was commenced before Mr. Ranjan Bachawat, senior advocate. And the statement of defense and counterclaim is filed by Mahesh Kejriwal. Same person.
Page 109.
109. My lord, please see page 145, starts at 109, counterclaim of Mahesh, respond number 2, page 145 are the particulars.
$145, yes.
Yes. Deposit made to DRET on account of PNB is A and B. Then payment to Indian Bank, legal expenses. And this is the counterclaim, page 147. So he's gone to arbitration, he's made this counterclaim, then he's abandoned the proceeding.
This is not there anymore.
No, he's not proceeded with his counterclaim. The mandate of the arbitrator has been finished. He has not taken steps to revive the mandate. That doesn't mean, what had happened was
My mission was the claimant, I was the counter claimant, none of us were proceeding with the arbitration, we decided to pursue our remedy.
No, you can't do that. I have not pursued my remedy anywhere else. I gave up. I start an arbitration. One fine morning, I decide I don't want to proceed with it. It lies there. It's, my lord, unless the proceeding is terminated under the Arbitration Act, the proceeding continues.
That arbitration was pursuant to some agreement between you and the...
Yes. And court-appointed arbitrator.
The agreement contemplated these kinds of disputes to be adjudicated upon. What was what was the scope of the arbitration?
Yes.
The
So, my lord,
point-
what had happened was, for this I'll have to go slightly.
Yes, because suppose the ambit of arbitration is X and his claim in the suit is also X. Then if X is to be decided by the arbitrator, the parties have approached the arbitrator and abandoned. Then it becomes
End
something
of the
else.
matter. No, the fact that he has gone somewhere with a claim, he's filed a claim, then, my lord, he's abandoned the claim. Either he'll say my arbitration is alive.
What was the scope of arbitration?
Arbitration was, as my learned friend tells me, it was in respect to a partnership firm. So that, my lord, parties must have.
Where these properties were also involved.
Yes. Subhadra Trading was the borrower. My lord, what had happened? I'll tell your lordship. A little bit of background. We had some partnership firms, we had some companies. Father and two sons were together. There is a family settlement. Foundry division comes to me. Machine division, which is not these excavator, etc., needed for mining, etc., they go to him. Machine division goes to him. Foundry comes to me. The companies which had the foundry and the foundry land comes to me. Partnership firms which had the machine division goes to him. Bank liabilities were to be met, my lord, as decided in the family settlement. So he takes over Subhadra Trading, the partnership firm. This is, my lord, this mortgage, this residential property was used, my lord, for the purpose of financial accommodation for Subhadra, which has gone to him.
I'm sorry to interrupt. The question before your lordship, my lord, in a 227 petition is whether these questions are questions that ought to have been gone into and adjudicated by the learned, my lord, court below. Now, my lord, my learned friend wants to address your lordship. Wants your lordships to adjudicate this matter, my lord, I have no problem. But, my lord, perhaps this is beyond the scope of the revision. The only question is whether, my lord, these are the questions that should have been gone into, my lord, by the court before directly, my lord, physical partition by meets and bounds through a special drafts. That's all. Well, I don't know where we are going with this.
Where the written objection takes us. Lord. So, my lord, so I had two arguments before the learned court below.
And where was this point of arbitration taken in a written objection you have taken?
Yes, this is, I'm showing your lordship written objection.
Yes, where did you say that these are?
Yes, my lord, I'll just show the paragraph. My lord, please see paragraph 8.
Paragraph 8.
8 at page 10. What I am telling your lordship is what I said to the learned court below. Paragraph 8A, same submission, 11A to 11D of application, subject matter of CS, and 11E to 11H, subject matter of arbitration.
Yes.
Yes. So, my lord, my submission is that the borrower was Subhadra. In respect of, my lord, Subhadra's Subhadra's partnership deed, which has the arbitration agreement, we went to arbitration, and this issue came up there. But please, my lord, ignore this. Whatever be the reason, he thought that that proceeding was competent to raise these claims. That's all that I'm on. And he made these claims.
And if he has not pursued the claim according
That's his
to the
problem.
his claim is dead.
He's claiming if he is not pursued, it's dead. If it is possible of revival, he will revive it. That's before the arbitrator.
According to you, it cannot be.
It can't be now brought here.
Cannot be asserted here.
That is all that I say. Now, my lord, I'll just sum up my points. Yes. It's also, my lord, part of the statement of defense that this property was mortgaged to the banks for Subhadra. So the proceeding was very much competent. But that is not, my lord, what I really want to argue. I want to argue, my lord, number one, I've shown your lordship the pleadings. There is no document produced by them which shows, my lord, mortgage has been redeemed. There are contradictory averments, my lord, made by them, which I've shown your lordship in the 151 application. In those circumstances, there is no material on the basis of which today your lordship can come to a conclusion that the mortgage has been redeemed. Especially, this is arising out of a suit. So he should have, during trial, raised this issue. And he did raise this issue. My lord, please see the preliminary decree once.
Page?
Yes, my lord. Page 122 at 150. Paragraph 82.
82.
Yes. This is where at the time of, my lord, passing the preliminary decree, the learned judge, my lord, says, I'm not even deciding this question now. I'm going to pass a preliminary decree. My lord, please see, my lord, paragraph 82. Before deciding the question, this is not page 149. Before deciding the question as set forth, I would like to keep it on record that for the present, I am not inclined to get involved into the question whether a suit property was mortgaged with the bank, who mortgaged the property, what was the purpose of mortgaging the suit property, for whose benefit the property was mortgaged, whether any amount has been paid towards liquidation of the mortgage, who has paid the money, etc. Plaintiffs have come before this court praying for partition of the suit property. At this stage, it is the duty of the court to decide whether plaintiffs are entitled to decree of partition as prayed for. What will be the consequence of declaring share in the property? How parties will be affected by decree of court, if at all any is passed? Question of liquidation of mortgage with regard to suit property in the light of the decree will be dealt with, all these questions taken care of at the time of passing of final decree. This is the preliminary decree. And if I say, my lord, with humility, this is absolutely correct understanding of the law, which is why this decree was upheld in appeal before this honorable court. Because, again, my lord, section 72, assuming that you have mortgaged the property, assuming you've redeemed as a co-mortgager, what do you get? Right akin to mortgagee. So what is that right? Right to foreclosure and sale. Where is your suit to foreclose and sale? Number one, you've not filed a suit. I can't, my lord, go around telling people I am is equal to mortgagee. I have to enforce my legal right.
You can't do it here.
You can't do it here. You can't convert the partition suit into a suit for, my lord, foreclosure and sale of mortgage property. That is right of mortgagee, which he claims to have got. But his claim, my lord, is shrouded in controversy. He doesn't say when he's got it. He doesn't say how he's got it. He doesn't give a document to show he's got it. He makes a contradictory statement saying that I have not got it. But let's, my lord, for the moment believe him. He says he's got it. If you've got it, what good does it do till you get a suit for, my lord, foreclosure and sale filed and you get a decree? Till then, you have a claim, and I humbly submit, before you go with that claim to court, you can only have it in your mind. Doesn't give you any right. Number one. Number two, you have made a money claim, yourself you have made a money claim in two other proceedings on the same ground. One is pending here, other is pending in arbitration. Arbitration, both have abandoned. By saying that I've made a money claim, you can't say that was an incompetent forum. You've never said it anywhere. And it is not an incompetent forum, because that arbitration is in respect of Subhadra. And Subhadra was the beneficiary of the loan. But be that as it may, you've made a money claim. In two Milord proceedings, on the same ground, you are stopped from filing a 151 application. Maybe your claims are now updated, but you can't do it. Also, my lord, please remember the prayer in the 151 application. It's not for sale. It's find out, Lord, please see the prayer once. 151 prayer is at page 1. Lord, I'm sorry, my lord. Lord, page 200. Adjudicate as to what is the amount due and payable. We are not on amount. You claim a right as mortgagee is equal to mortgagee for foreclosure and sale. I've shown that Supreme Court judgment. It's as if mortgagee. So you only have a right to file suit for Milord enforcement of mortgage. And you don't even claim that right. You claim money. Page 200, you claim money. And this money you've claimed in two other proceedings on the same heads. This is an updated version of your claim. So it's not permissible. Number 3. Just kindly give me a moment. Yes, partial, last point. Even if it's a partial, Milord, redemption, there's no subrogation permitted. That's, Milord, the proviso to section 92. Now, please see 92. No, no. Milord, 92, last, Milord, nothing in this section. That's not a proviso. I'm sorry, I was wrong. 92, last part. Nothing in this section shall be deemed to confer a right of subrogation on any person unless the mortgage in respect of which the right is claimed has been redeemed in full. He's not shown anything. He's only shown part payments all around. Contested issues. So, partial redemption doesn't get you subrogation. So this is, Milord, the situation. Now, next chapter. Why is, Milord, let's assume again that he is right. What does he have? Right in money. Milord, property will be partitioned. He can't stop the partition. Number 3. Let's assume, Milord, he has 92 rights to file a suit for foreclosure. His right, Milord, a statutory right, will not, Milord, be washed away. It will remain. If you have the right, you file your suit. Next, Milord, by making money claim in those other two proceedings and asking for money in this proceeding, you've given up your right of mortgage of charge. And lastly, why is he doing this? Milord, just 4 documents. And I'll stop, Milord, immediately. Milord, please see. This is all written objection, page 31 and all that. Only to delay, Supreme Court, page 31. Milord, my written objection once more, Milord. Yes. I'll just quickly take your lordship through. Milord, this Mr. Banerjee always says, that is my favorite topic in this matter. He gets angry. He is not here.
To finish it before he comes.
Yes, I'll finish it before he comes. But I am grateful to him, Milord. I've got.
For getting angry on you?
Yes, Milord, he gets angry. I also, Milord, help the situation by making a comment like this all the time. Mr. Banerjee, thank you for another brief.
So he left at the right time.
Yes. Milord, ঠিক আছে। Milord, page 14, Milord,
the point.
straight to the point, he's been, Milord, delaying the matter, but the client, not him. I'm sorry, Milord, I shouldn't be misunderstood. Milord, please see page 14.
Page 14.
Yes.
Yes.
The first order for disposal of suit in 6 months. Page 14 at page 16, last paragraph. And this is 2015. Then page 17. Second order of this honorable court for disposal within 6 months. Again, page 20. This is on a clause 13 application. Then, Milord, page 21. Third order of the hat trick, Milord. Third order of this honorable court. Another clause 13. Expeditious disposal, recording earlier 6-month direction. So 3 orders of this court. Now, Milord, page 23. Oh, there is also, Milord, Supreme Court. Na tar age Supreme Court chilo na. My mistake, Milord, there was. Yes, there was a Supreme Court order which says 3 months or something. Page 31. Page 31. Milord, so many of these orders. Milord, at 32. Complete hearing and deliver judgment within 4 months. 31 at 32.
After this preliminary decree was passed.
No, after this also not passed.
No, it was passed because this is of a 20. This
is 24.
24.
No,
March
I'll tell your lordship.
I found it was March 2025.
Yes, but after page 23 it was passed. See page 23. So after this also nothing was happening. Milord, very inventive interlocutory applications.
But it's well within 4 months. Preliminary decree is well within 4 months of.
Yes, so they were not doing anything. We went, Milord, because so many applications not allowing it. So we filed for criminal contempt. So I'd gone, Milord, we wrote to the learned Advocate General. Advocate General said, no, this is not criminal contempt because every adjournment is a rejection by a judicial order. So it can't be criminal contempt. We still persisted. You can challenge the judgment in court, Milord, in a criminal contempt petition. We filed and we persuaded, Milord, the division bench to pass, Milord, page 23. The justice, Milord, can't be defeated in this manner. You can't stop a suit. Milord, paragraph 3, learned judge, Milord, did not direct anything, said deeper deliberation would be required. Then, Milord, page 25. Milord, it started. 26, Milord. What they were doing is, Milord, recorded. Then 26 at the bottom, Mr. Satyanthat submits that they do not support the conduct of the litigant before the trial court. They assure the court that if a last opportunity is given, they would conclude the evidence. And then, Milord, lawyer was, Milord, misbehaving. So, Milord, costs and personal apology. And then ultimately, Milord, page 29, evidence was completed and it was monitored by the division bench. Milord, evidence was completed and the matter was disposed of. And then comes the decree, preliminary decree. Then appeal, when it goes back, partition commissioner is prepared and filed a report. Now, before final decree can be passed, comes this application. And they move it on 22nd of December. Now, learned judge says that this requires hearing. I can't say it doesn't require hearing. I can't say, let's not go home, let's do it on 22nd December. So, Milord, we literally agreed to a stay, but doesn't matter because last week, Milord, I'm told, Commissioner of Partition has submitted report, filed report. So it's actually not been a problem at all. And matter was today, we'll take an adjournment today, waiting for my Lord's decision. So this is the conduct. This is another way to forestall, Milord, passing of final decree. So A, his money claim can't be affected by the decree. B, his perceived right under section 72, if he has any, can't be affected by final decree for partition. C, this is, my lord, I hope, my lord, it would be the long end to an illustrious list of interlocutory applications. And final decree, my lord, we have also given, my lord, page 4 of the written objection. Kindly see. 26 interlocutory applications from page 4. All have been dismissed. No. 52 is wrong. In the 52 is wrong. I apologize. It's 26. How did I doubled it in my mind, Milord? I stand corrected. Milord, please see page 4, para G, 1 to 26. And this 151 is 27. And he's got, Milord, 26 dismissals. I never knew, Milord, that there were 26 provisions of the Civil Procedure Code which permitted an application to, Milord, stop proceeding of a suit. The genius, Milord, has advised, and I am grateful, my brethren have received more work. So, Milord, these are my submissions. Milord, partial subrogation, he's got a judgment. Partial repayment, no, Milord, no subrogation. And my learned friend is insisting. Milord, may I?
Yes.
Milord. সব দেখিয়ে দিয়েছে তো Milord, at 6:34 Calcutta Law Journal. I hope it's not my book which has been photocopied. Milord, volume 5 CLJ page 611. 5 CLJ 611. At page 634. Milord, Milord, middle of the page.
Yes.
What would be his position with? I'm sorry, Milord, let me read a bit more. It is obviously it will enable a person. What would be his position with regard to interest subsequently accruing upon prior mortgage, etc.
The person who makes the payment.
Yes.
From there, if you read.
It has to be full payment. The rule, therefore, that before one creditor can be subrogated to the rights of another, the demand of the latter must be entirely satisfied, so that he shall be relieved from all further risk, trouble, risk, and expense, is based upon good sense. আমার বই স্ক্যান করেছো শুভাশিস ফোন থেকে So, Milord, these are my submissions. Would your lordship permit me to just give the bullet points in a one-page note? Just the points.
Yes, just the point. Don't make it very lengthy.
No, just points.
2 pages.
2 pages notes.
Yes, Mr. Saha.
Lord, may I have leave of your lordship?
I can come back, my lord, because two judges.
Up to you.
26টা কি করে হলো? It is a question. How did 26 become 52?
My learned friend, my lord, he invents, innovates arguments, my lord. All credit to him. My lord, in his mind, he also innovates numbers.
I must have thought it's 52. No, it's on my mind. I've been saying 52 all the time. It's actually 26.
That, my lord, this, my lord, matter could have assumed this dimension is also something I'm learning.
When can we have it?
And I can come back, my lord.
Next week. Up to you. Tell me whenever.
My lord, next week, my lord, anytime. My lord, apart from the 5th of August.
2 p.m. কবে হবে
We can have it on 7th then.
7th
Friday.
Yes, of course.
2 p.m.
I'll bring my note on the 7th.
Yes.
I will also try to come with a short 2-page bullet.
2-3 pages. Third, Mr. Chaudhary, learned similar and preparing for the opposite parties.
In battery? I think I have an arbitration before you.
এটাই
my application in a testamentary suit for appointment of commissioner for examination of my two witnesses. Lordship, my first witness is the attesting witness. My lord, Lordship, he has to be examined first. For him, Lordship, I have made a prayer that he may be examined first, Debenese, and thereafter, Lordship, my second witness, who is the propounder, Lordship, that he may be examined.
Why on commission? Ill.
Lordship?
Why on commission? Ill.
Okay.
Why is it to be done on commission? He or
Lordship,
she can't
no,
come.
not filing, Lordship, examination.
Why is it to be done on commission? Why the examination is to be done on
Lordship,
commission?
The reason that the first witness, Lordship, he is aged. So that is the first. And the second, my lord, I'm saying that since everything is happening, let it to expedite the suit, let both my witnesses be examined in commission. Lordship, after the amendment, Lordship, now it is a matter of
Which amendment? I don't know. Tell me.
Lordship, that is not the case here.
Order 26, my lord.
4A বলছে তো?
4A is even 4A.
Yes.
That is not the case here.
Let him conclude. Yes.
Kindly takes order 26, rule 4, and then rule 4A.
Yes, order 26, rule 4.
Rule 4, Lordship, what it used to be, any court may in any suit issue a commission for examination or interrogatories or otherwise any person resident beyond the local limits of jurisdiction, any person who is about to leave such limits before the date on which he is required to be examined in court, and any person in the service of government who cannot, in the opinion of court, attend without detriment to the public service. And there are provisos. Lordship kindly takes now 4A.
See the second proviso. Why should I think it necessary to be so? Because
Lordship,
it's not.
That is why 4A, Lordship, will see.
Yes.
Commission for examination of any person resident within the local limits of jurisdiction of the court, notwithstanding anything contained in these rules, any court may, in the interest of justice or for expeditious disposal of case or for any other reason, issue commission in any suit for examination on interrogatories or otherwise of any person.
It can't be leisurely. It has to be for reasons which are, because the usual process is to face the witness box.
Lordship,
if you want to avoid
now
it, you have
is
to show
a matter of
sufficient
course,
reasons.
my lord. Lordship, I have annex, my lord.
Can't be matter of course. Then provisions will have to be scraped up. There will be no evidence in doc. Can't be
It is
matter.
not that they are not getting to cross-examine.
Even then.
But what is my learned friends? Why should so shying away from facing the cross-examination in open court? And one thing I want to add is not it's not the
This is Lordship, they have been,
একটু বলে নিই দাদা। It is not the case.
I can bring my witness today. The Debenese, Lordship, then my prayer is allowed then.
It is not the case that the petitioner as well as the attesting witness is being sought to be examined on commission. Clear case is that at paragraph number 10, that one Mr. Probir Das is currently about 64 years old and not the petitioner.
No, not the
Currently about 64 years old and suffers from various ailments due to his old age. So I will like to submit, Lordship, because I have instruction that he is not at all, he is not at all suffering from any ailments and no documents have been, my lord, annexed along with the petition in this respect. And before section, my lord, order 26 rule 4A comes into play, we have order 26 rule 1, where the petitioner says that there is some ailments and some he is sick, but he has not filed any documents along with it. So, my lord, he has to first, my lord, cross that obstacle. I need to file a written objection in this.
Very well, my lord. And let him not be examined on commission, Lordship. But my first attesting witness has to be examined first, my lord, because he is a senior citizen.
Then
Lordship,
when can he come then? We'll have
any day, Lordship.
That is not the prayer. The witness
not required.
He is
we can
not
say that.
letting me
I can
proceed with
treat
my
this.
suit.
You can't just put a spanner in the wheel both ways. If he is ready to come in court, let him come in court.
Yes,
and commission will be at my expense, not his.
As far as commission is concerned, I have objection, Lord. I want to file written objection to this application.
No question of written objection if he is willing to come over here and face the witness.
Yes, then I'm not opposing. As far as commission is concerned, I am opposing.
Lordship fixes any day, Lordship, the next week Lordship fixes, he will come.
Your Lordship.
May it please your Lordship. Not appearing on behalf of the respondent in this matter, my lord.
I'm appearing for the petitioner, Your Lordship. I'm led by Mr. Jishnu Shah in this matter. Your Lordship may kindly keep it not today.
Great. But I was only humbly beseeching, my lord, if an opposition can be, my lord, we can file, my lord. What is this? This is the matter, my lord, for revocation of a probate. Probate has been granted in 2024. Now they have come up with this application for revocation. I just wanted to, and moreover, my lord, the applicant is a third party who is
Your
not
Lordship,
even a creditor of the deceased.
Not today, led by Jishnu Shah.
Let him come tomorrow, you will pray.
Grateful.
My lord, pick to appear on behalf of the applicant, my lord. My learned friend was on the last occasion argued, without death certificate, whether, my lord, the probate proceedings can be further, my lord, advanced. My lord, we have checked, my lord, Succession Act 1925 and as well as original side rules. My lord, it seems, my lord, it is possible. How it is possible? At the very outset, my lord, I am referring, my lord, the relevant provision of the Indian Succession Act. That is 276. Lordship, kindly see him. May I hand over, my lord? I have additional copy, Lordship, subject to the Lordship. Lordship, see, my lord. Kindly see, my lord, 276. Petition for probate. Application for probate or letter of administration with the will annexed shall be made by the petition distinctly written in English in the language or in ordinary use in the proceedings before the court in which the application is made. With the will or in the case mentioned in section 237, 38, 39, a copy, draft or statement of the content thereof annexed and stating the time of the testator's death, that the writing annexed in his last will and testament, that it was duly executed, the amount of assets which are likely to come to the petitioner's hand, and when the application is for probate, that the petitioner is the executor named in the will. In addition to this particular, the petition shall further state, when the application is to the district judge that the disease is at the right time. This is not relevant, my lord. My lord, here our humble submission, death certificate is not mandatory. My lord, we are by swearing affidavit, my lord, make this submission that only son is there. My lord, the gentleman during his lifetime, without, my lord, executed this particular will, and my lord, it was settled in favor of the person who is before this honorable court as executor. My lord, the relations, those who are going to be deprived, they are not in a mood, my lord, to hand over the copy of the death certificate. He died in Madras while the treatment was going on. That being the situation, my lord, the question of citation, other things, and if this honorable court thinks it proper, my lord, direct us to publish in the newspaper. The legal air questions are there, my lord. We are not hiding anything, but at the same time, my lord, our humble submission, the death certificate not readily proceeded with. My lord, what is more, my lord, I am fortified by the division bench judgment of this honorable court, that is an original side rules also, my lord. Kindly see, my lord, this is 2005 SCC Online Calcutta 332, paragraph 21. 21, we thus find the learned Chief Judge City Civil Court refused to exercise jurisdiction vested in him by way of holding that in absence of death certificate and other certificate, it was not possible for him to grant the relief claim. The law does not require that the fact that a person is dead must be proved only by documentary evidence. In a civil litigation, finding on all disputed question of fact, including the time of death, can be arrived at from the evidence on record by applying the principle of preponderance of probability. Similarly, in the proceedings under the Act, the court will, on the basis of evidence adduced by the parties, come to the conclusion whether the person concerned was really dead and whether such person had a fixed place of residence within the territorial jurisdiction of the court at the time of his death, and whether all the person who could be his natural heir in case of intestate succession have been served or not.
And what is your prayer in this application?
My lord, here, my lord, at present we are not, my lord, to proceed further, my lord. Citation may kindly be issued. Otherwise, department is not in a mood, my lord, to issue citation and all other follow-up action. My lord, they are insisting us to produce death certificate. Death certificate is not with us. It is lying with the near relative. My lord, his estranged wife was there and divorce decree obtained subsequently. The son is only there. Other persons are not. And they did not hand over, my lord, the copy of the death certificate. My lord, whether request made dishonored or not, we are not in a position, my lord, to say. But we'll execute it.
I'm keeping it tomorrow. I'll consider. We'll hear and pass orders to
Last. Only one thing, my lord, the original side rules is also in our support. My lord, I am showing, my lord, only thing. That is, my lord, chapter 35. Chapter 35, testamentary and intestate jurisdiction. My lord, the rule 4. Application for probate or letter of administration or a certificate. My lord, here the same thing which is written in the, my lord, the Indian Succession Act.
We are not shy of producing the death certificate, but now it's not happening. So,
Chapter, my lord, 35.
35.
Rule 4. Application for probate or letter of administration or a certificate.
Rule 3.
Every application for probate or letter of administration with or without the will annex shall be accompanied by, these things are required, my lord, for filing. My lord, the death death certificate is not mandatory.
So we can use the
My lord, he died in a Madras hospital, and we have, my lord, nowadays lordship knows, it is to be issued by the local authority, municipal authority for death certificate, but the hospital authority issued the certificate. That is lying with us. We have enclosed with our application. My lord, that deeply obliged.
Just making it not today, tomorrow we'll issue.
Deeply obliged. Deeply obliged.
Yes.
The matter where due to my inadvertence, the column in the immovable assets has gone down wrongly. In the amended portion, your lordship was pleased to grant me liberty to take out a supplementary affidavit. But I have taken out a supplementary affidavit to that effect, my lord. in my original application, my lord, at page 51, my lord, that is the internal page of the amended affidavit of assets, the investment has been gone down as nil.
That you have corrected in
That
the
I have corrected, my lord. But in my supplementary affidavit, my lord, in the supplementary affidavit, the amended affidavit of assets has been marked as X. So I humbly beseech your lordship, if the order may be recorded, that the X in the supplementary affidavit may be treated as my amended affidavit of assets.
with an application.
Six, my lord, I am for the petition. My lord, my prayer for issuance of general citation at the collectorate of Patna. The property belongs to Patna. And the testator was the only son of his late parents and he was unmarried.
And for the petitioners, my lord, in the will there are two named executors. Both are before your lordships as applicants. Today, my lord, I am praying for issuance of citation. If your lordship kindly comes to paragraph 7 of the petition. I'm praying for issuance of citation. There are two named executors. Both of them are before your lordship as applicants. So if lordship comes to paragraph 7, I am praying for citation to be issued to Shonat Kumar Maha, that is number 2, 5, 6, and 7. So 5, 6, and 7 are the heirs of 1. They have consented, my lord. My lord, three is the one of the executors. So is a petitioner, and my lord 4 has given a consent which is annexed with the petition. So my lord 2, 5, and 6. The addresses are also mentioned in here, my lord. So I'm praying for a citation to be issued. In terms of prayer A, in terms of prayer A.
number 8. Item number 8. Resolution 71 Item number 9. Item number 9. Item number 10.
Lord, we are not confirmed whether the department has carried out the amendment or not, and therefore I am requesting for 2 weeks time. Item
Item number 11.
May it please your lordship, my lord, this is my application for seeking letters of administration. Lord, the will is dated 11th April 2021. Lord, the estater passed away on 9th of June 2021. Your lordship will find the death certificate at page 10, at page 11. And the will, my lord, is on the next page. It's dated 11th April 2021. To attesting witnesses, there's no named executor in the will. Therefore, my lord, the letters of administration, the legal heirs, if I may take your lordship to paragraph 5 at page 3. The deceased, my lord, passed away as a bachelor, and 4 brothers and 1 sister. They are the legal heirs, and my lord, all the consent affidavits are before your lordship. All have consented. 5 June. Affidavit of assets is also, my lord, before your lordship. Even, Shashikant. 5টা থাকবে সব মিলিয়ে। Affidavit. Lord, I am told the affidavits were filed a second time. For এটাতেও ভুল আছে। Yes, my lord. My lord, my lord, I think because of the spelling mistake, I'm case হতে পারে। But I'm told it was because of the same error that the spellings or some of the names were incorrect. I'm told it is correct now. If your lordship wishes, my lord, I'll Raveen Vithal Bhai is there. Bharati Thakkar is there. Okay. I think I also don't have it, my lord. I'll very well, my lord. Kindly, my lord, passes an order. I'll take inspection, my lord. That's better. That's better. Very well, my lord. 2 weeks, my lord. That should be sufficient. My lord. I'm grateful.
Lord, I'm appearing.
Very well, my lord. We'll do the needful, my lord.
My lord,
Very
this
well.
is my
Great.
application, but
Of course, my lord. It has to be rectified.
my lord, the beneficiary is in the judicial custody, so I need instruction. I am praying for at least 4 weeks' time.
Wife predeceased, all the death certificates are annexed. Son and 2 daughters. 2 daughters have given consent. Son is the executor. My lord, wife predeceased. I have annexed the death certificate. Three years, 2 have come. The executor and son years.
Contentious cause. Property outside. The only issue is, if not kindly takes two orders. Technically, we got no issue. Registered will, consent affidavits, affidavit of the attesting witness. There were two orders. One was where, in accordance with the 16th January judgment, I was supposed to serve citation. That is no longer required by my lord's order itself. Sitting in division bench. And on the last occasion, a direction was given to comply. Now I am seeking, to state that there is no compliance required of that order. In terms of the order passed by my lord reported in 2025 SEC Online Calcutta 7999. Not soft copy I have, may I hand? It is. Relevant portion, my lord, is marked at page 31, at paragraph 31. নিজে অর্ডার থেকে খুশি হয়ে মানুষ দেবে
No, not required. Citation was not required. 15, 14.
The next is identical. It is for the will of the son of the testatrix in the last.
That will be another meeting.
May I just- Mr. Ratanlal Duggar's will passed on 26th May 2020. Now we'll find the death certificate at page 10. The will starts from his mother. This is the son.
This is the
who
son.
passed away after. Yes, he was one of the two named executors. Yes, they were all there. Heirs are also mentioned in the previous.
The son was not there. যখন file করেছে।
Son was not there. Son passed before the filing.
Yes, yes, yes.
Now we see the probate matters are dated 2023. So and so 2023, son passed in 2020. Now page 10 is the death certificate. There is no discrepancy. My lord, continue. Now death certificate, my lord, will find at page 10, 26th May 2020. The will, my lord, will find at page 11. The executor name is the eldest son, my lord. Now will find the executor's name appearing at page 15, which is internal page 5 of the will, my lord. The top paragraph. My lord, page 15. Page 15. Yes, my lord. The executor's name is the eldest son, which is Rajesh Kumar Duggal. My lord, page 17, my lord, will find that there is no intimation of any other court. The maximum stamp duty has been paid. My lord, the documents are at page 18. Yes, my lord. The consent affidavit, there are the legal heirs, which is the wife, the daughter, and the son. All consent affidavits are there. And there is also the affidavit of the attesting witness, Mr. Shrutanu Chandra. Suffered that paragraph will not be omit.
10th March order টা খালি ছিল।
Only the 10th March order was there. No, কি বলছেন?
Oh, হ্যাঁ, sorry.
I am sorry, Milan. That paragraph remains. That paragraph remains. I apologize. I apologize.
Yes, I have attempted. Great.
Lord, I appear in support of this application. Lord, it's a wife will in which husband is the executor and son and daughter has consented. Therefore, my lord, only thing, my lord, a notice has to be issued after the probate under the rules. That is Rule 36 of Chapter 35. Rule 36, Chapter 35. Notice to the collector. Because there are land outside. That is the only direction the probate I need, my lord. Otherwise, there are no other difficulties in grant of probate. After কবে তারিখ দিলে?
I beg to mention item 29. It's listed for a very limited purpose. Malats, I have come all the way from Delhi to argue this application. It would be disposed of. I will take 3 minutes to satisfy your lordship. Malats, this is for final disposal applications coming up. Only interest-bearing component is left out. If your lordship can accommodate to hear, other side may be present in court only, Malats, for 29. We expected the hearing yesterday, but somehow your lordship posted it for today. And then also the time changed from 2 p.m. to 3 p.m. I was waiting for a long thing, Malats. Malats, the court officer said that it will come up today, but I was not aware it will be shifted to 3 p.m. onwards, Malats. Malats, I will take 2 minutes, Malats, if and I'm in your lordship's hand. If it could be taken up tomorrow anytime, like, it's a very small purpose which is left out, Malats. Yes, Malats. Will right, Malats. But at the original site timing, Malats, from 2 p.m. All correct, Malats. Malats, in that case, this matter will be forwarded for tomorrow, in tomorrow's cost. Same. Grateful, your lordship. Grateful, your lordship. I understand, Malats. Malats, I'm obliged. I will put them on notice, Malats, by today.